Sudipto Sarkar appearing for defendants 1 and 2. Lordship is traveling abroad. He has requested if it can be fixed at 12 or 12:30 on Thursday. Or any date, any day after Thursday at 12.
The other side.
No, my lord, after Thursday, my lord, I would be objecting, my lord. No,
Lordship, if it is on Thursday, 12,
I am
12:30.
not objecting to any other prayer, but my lord, delaying the matter will cause some problem.
Very well, let it be on Thursday, 12, 12:30.
I have not time.
Lordship,
I will fix the matter we want on any date, but I will not fix the time till September. That I will not fix any date for because my diary is totally packed.
Lordship, then can it be kept under to be mentioned tomorrow so that we can take necessary instruction and we can come and fix a time?
You mentioned not necessary for to be mentioned. You mentioned you take the instruction, but I am clarifying you till September before puja. I am not fixing. My diary is totally packed.
Very well.
Mr. Thakkar had in fact made this prayer, my lord had already indicated.
It is totally packed my diary. I cannot fix any specific time. If you want any date, I will give the date, but I will not fix any case for any specific time.
Well, my lord,
if you want, you take the diary up from my
lord.
court officer and you can check.
My lord, I will mention again tomorrow.
Yes.
My lord,
My lord,
may I be permitted to mention, this is item number 146 of your lordship's list today, under the heading witness action. This is arising out of an undefended suit. My lord, my witness is otherwise ready. I was humbly beseeching if your lordship could fix any day. I have
146.
Yes, your lordship. The first matter under the heading witness action. Any particular day, as I understand your lordship cannot fix any time, but any particular date when I'll ensure that my witness remains present in court.
Commercial.
Yes, it's a commercial suit. It's a commercial suit. It's all ready and it's undefended.
उसमें कब है? Last date कब है? Record and all. 146. Though the matter is fixed today under the heading witness action at serial number 146. The counsel for the plaintiff prays for fixing a date so that the witness can depose before this court. We have therefore let the matter appear on 18 September at 2 p.m.
Grateful to lordship.
my lord, a similar prayer, my lord, item 167, it was item number, my lord, at fixed at 2 p.m. yesterday. So, my lord, I could not assist your lordship. 167. My lord, it was fixed. My lord, for the witness action, my lord, it was fixed yesterday at 2 p.m. My lord, any day may be fixed, my lord, any day.
Let the matter
At time.
18 September 3 p.m.
May I have your lordship's kindly mention, my lord. Item number 4 of your lordship's non-commercial list, my lord, fixed for witness action, my lord.
Yes.
My lord, my witness is unable to come today, my lord, on account of he's not well, my lord. My witness is not.
Matter?
My lord, item number 4, fixed, my lord, non-commercial list.
So this was fixed in the presence of parties on 20th June. January 2025, my witness action has been closed. Defendant's witness, time and time again.
It's not well, my lord. I pray before your lordship any day, my lord, in the month of September, my lord, subject to your lordship's convenience.
Okay, subject I will give the date, but subject to payment of cost of registration.
My lord, kindly, my lord, not be prejudiced. My lord, he's not well, my lord.
Come at.
My lord, let us come back at
All bar members knows with regard to the fixed date what the court is to be.
Lord, I just pray, my lord, any day, my lord, in the month of first week of
Yes,
September,
you tell,
I'll ensure my witness.
I am not telling I will not fix the date. I will fix the date, but subject to payment of cost. And that too is High Court Legal Service Authority.
My lord, may I come back at 12:30, my lord?
Why 12:30? When the matter is fixed, you come at
12:30, my lord.
come at 12:30.
Praying for my lords, kindly to mention.
Okay. Make sure you have to make the payment.
May I have your lordship's kind leave to mention a matter virtually, my lord?
Yes.
This, that Statesman House matter, my lord, where I had appeared when the plaint was being presented, we hadn't been served with the plaint. In the order, it's gone down that I was appearing for the defendants. I am for Merlin, my lord. That's what I wanted to indicate to your lordship, because the caveat is by, my lord, my advocate on record, Sharma Kajaria and Company, for Merlin, and I had appeared. Now that we have the plaint, my lord, the defendant number 2 is the purchaser.
Okay.
My lord, both of us, my lord, are aware. My lord, my learned friends for the plaintiff and I are aware of the particulars of the purchaser. So, my lord, they have to give it to the purchaser separately, which is why I was mentioning.
So now what you want?
Milord, the small correction, Milord, in the order where it says that Vishnu Chaudhary appeared for the defendants.
Who is for the plaintiff?
Mr. Roy is there, Milord. Milord, in the
Let me tomorrow has to be mentioned. I will come tomorrow has to be mentioned. I will correct that because other who is preparing. I am correcting this order. The matter is listed now. The matter is mentioned by the Learned Counsel for the defendant number 1.
Yes,
Mr. Vishnu Chaudhary, Learned Senior, submit that in the order dated 1st August 2025 at page number 3, paragraph number 10 and 11. 10 and 11, it is 10 and 11. It is mentioned that the Mr. Chaudhary is appearing for the defendants, but he is only appearing for the defendant number 1. In view of the submission made by the counsel for the defendant, Mr. Vishnu Chaudhary, Learned Senior Advocate, in the order dated 1st October 2025, at paragraph 10 and paragraph 11, in the last line, the word defendants shall be read as defendant number 1.
I'm grateful, Your Lordship. Grateful.
May I have kindly, Lordship, I'm mentioning for inclusion of a company application. Company petition.
Come, Wednesday too.
Let it appear.
Come and because my company officers are not here. Come at 2.
Wednesday.
May I have your Lordship's kind leave to mention the Duarte matter on notice to parties, my lord. If your Lordship recollects, my lord. My lord, I am appearing for, if your Lordship recollects everything, my lord, 6 and 7. My lord, Mr. Thakkar was appearing for the plaintiff. My lord, pursuant to the appeal court's order, my lord, we were heard extensively, hearing concluded, notes of argument filed, so far as 6 and 7 reserved. Now, my lord, that has been quite some time. My lord, now the other defendants are coming, arguing, continuing. So, I respectfully beseech upon your Lordship, my lord, so far as 6 and 7 are concerned, my lord, let that judgment be delivered to the extent of 6 and 7. Because, well, otherwise, your Lordship, the entire exercise.
I remember on that day the matter one of your
colleague,
I specifically asked, you tell yes, it may fix. I specifically asked, I know you are making every day you are making the submission regarding 6 and 7, but some of the defendants are asked for the time and specifically asked who is, I could not remember, who is your junior or your colleague.
My lord.
I especially asked whatever, yes, it may be fixed on.
I'll tell you, Lordship, why. Because otherwise, the entire exercise, the judicial time that your Lordship has given to us, well, everything will become, because the other arguments are not yet complete. So, well, the entire exercise will be a futility. So, because we stand on a completely different.
When it is fixed?
20th, can you imagine?
Fixed it. My lord, we were replying to the arguments or submissions made by defendant number 10 and 11.
Very well, that continue.
We'll finish it out.
6 and 7, they have also filed their notes, confined to 6 and 7. My notes are complete, our argument, rejoinder, everything is complete. So, well, so far as 6, because we stand on a different footing altogether. Other defendants are entirely different cause of action.
It remains the 10 and 11, nothing else.
10, 11 and 12. My lord, others have not made any submission. Defendant number 8 and 9 and defendant number 13 and 14 had filed a separate vacating application, but they have not made any submission in respect of GA1, which is my injunction application.
So when it is fixed at 28, what time?
20th.
What time?
My lord has not fixed any time. Fixed on 20.
So I was 2nd of May we filed our notes and our hearing was concluded. Summer vacation went. So because your Lordship can understand another defendant will come, then Mr. Thakkar has to naturally respond. So this will continue. So I was respectfully submitting that since your Lordship, my lord, I don't wish to repeat, my lord, your Lordship can understand what I am saying. So if that could be done. Notes filed, both parties have filed the notes also.
To be mentioned, day after tomorrow to be mentioned.
Well, deeply obliged. Notice tak hota hai.
You the notice to
notice.
Wait.
Yes, call.
May I have the liberty to mention the matter? My lord, I'm mentioning upon notice. My lord, this is an application. I wish to prefer to applicate debarrer application, my lord. This matter, Lordship has directed to come on 7th of August, my lord. I have caused advance service. My lord, I wish to take leave from your lord for short service.
For what?
I wish to file two demurrer applications.
No, what is the 7th August? What is fixed for
7th August, other applications, there are.
Okay, come on that day. You file in. Why the short
My lord,
notice?
in the normal course, it would come on the 9th.
Let come on, whatever it may be. Well, it will come. Let it be.
I am appearing for the plaintiff in this matter.
Yes.
May I have my lords kindly, my lord, to mention, my lord, two undefended suits.
Hmm.
My lord, in this matter, your lordship remembers, my lord, this matter is in the stage of arguments. Then, my lord, during the arguments, your lordship, it was pointed out by my lord that an application is to be filed asking the defendant to disclose the original agreement, because we had tendered the copy of the agreement, my lord. That application has been filed, but my lord, the business of the court is not permitting my lord to take this application. So I'm praying just, my lord, for upgradation of these two matters. These two are undefended.
No, I have taken all new motion on the last week.
Lord, it is appearing along with the suits. So
I taken all new motion in the list. None of the new motion on the last month. None of the new motion has kept pending.
Lord, may I just clarify for a moment? This application has gone with the suit heading, so it is there appearing. So that is why I'm just praying for upgradation. If it's that is why, my lord. It hasn't.
It can be done if the system has done like this, and if any application is filed, it's coming under the heading suit. If the suit is
That
filed,
is why, my lord. Otherwise, the application would have been taken.
New motion will have.
Extremely grateful, my lord.
Yes, call the list. Non-commercial.
Item number one. My colleague will be giving is listed for handing over the notes of arguments.
No. It is not. It is not.
The other one.
It is non-commercial. I will just.
I'm so sorry.
Yes.
We are for the defendants. Grateful to
I am appearing
Mr.
for the
Chaudhary that
plaintiff.
parties have settled on Saturday
I
itself.
want to,
Withdraw this suit.
I want to, express my gratitude, my lord, for the hearing before your lordship. That we disturbed your lordship, but now finally parties have seen sense and have settled the matter.
Okay.
That I want to withdraw this.
It's good news.
And it
That
happened
is
on
good.
Saturday itself.
Lordship, let the withdrawal be without liberty to file afresh.
Mr. Kochar, please appreciate that these are not well taken. Nobody is asking for the liberty.
Counsel for the plaintiff has handed over the communication dated, email dated 5th August 2025, wherein the plaintiff has informed the learned advocate on record of the plaintiff that the parties have settled their matter, and thus the plaintiff is not interested to proceed with the matter and requested the learned advocate to withdraw the suit. In view of the communication dated 5th August 2025, learned counsel for the plaintiff placed for withdrawal of the suit. In view of the submission made by the counsel for the plaintiff and the communication dated 5th August 2025, CS 13 of 2025, within bracket Jayasurana versus the Calcutta Swimming Club and others, is dismissed as withdrawn. Consequently, all applications is also dismissed as IASB.
Yeah, all IASB.
Yes.
Communication. Yes.
We are grateful to your lordship.
Thank you.
We are really deeply.
नहीं हो तो सब जोड़ो ना जाने दो.
Yeah, of the applicant objector, I'm filing my written notes of argument.
Yes.
As per your lordship's direction,
Excellent.
Yes.
But the difficulty is that, my lord.
may I find
Which
my
one?
report of the
Which one? Item 1.
Your lordship has
Well, there's a receiver, if your lordship recollect, 42
Acha,
lakh
acha,
pursuant to the executing court's order.
Okay.
So your lordship said,
branch of HDFC.
I'm led by Mr. Raman Hingoran. He is online.
I'm online. We had concluded the arguments. The Honorable Court is pleased to the report of receivers. They will only know what is the status of the amount there. We were directed to file the notes of arguments.
Yes.
So my colleague is filing our notes of arguments on behalf of the objector. Only one request: all the previous order sheets reflect us to be the respondent, while we are the objectors.
I will take
So I
time.
just want the correction to be done. That's all.
Yes, Mr. Bose, You are filing? You are.
No, my lord, I'll tell your lordship, my lord. Our note has gone to 70 pages. My lord, 36 judgments have been cited by my learned friend. So we have not been able to understand how to deal with.
How
Because
many
if we
pages?
start
How many pages?
70.
70.
So I am trying to shorten that 70 pages of note. My lord, but I mean, dealing with the judgments have gone into 42 pages. So he said that is not possible because then it becomes a petition, not a notes of argument. We have counted 36 judgments. My learned friend, correct me if I'm wrong.
Has taken about 10 hearings, so that's why it's bound to be lengthy. Actually, this is almost like final argument, so should it go for trial? We've been struggling to go for trial in this matter.
No, well, I am sure you would have gone for trial if that division bench judgment was not there.
When you file?
Lord, kindly give us at least 2 weeks time, my lord.
2 weeks.
Because what I'm trying to do is that, my lord, shorten the whole thing so that it makes some sense. Because
Today
we cannot.
are on 5th.
Because our principal point is the division bench judgment. Whether the division bench judgment and the cause of action which was decided, does he still have the cause of action to pursue Order 21, Rule 58 or not? There, my lord, 36 judgments have come. So, my lord, give us 2 weeks.
I've addressed all those concerns. My only point is now they have unfair advantage. They got a copy of our submissions.
No, we haven't. We haven't got anything.
No, we are filing it today. Unless we also file it after 2 weeks.
You're most welcome. Not that I wish to look at your note to prepare mine.
Only one thing, my lord. Your lordship, my lord, I have already, my lord, the learned receiver has already filed the report. My lord, he is, my lord, above 80. So if your lordship would kindly,
I will dispose of all.
my lord, your lordship would kindly release him because all the bank accounts and everything he has
many years now, only 15 days, matter of 15 days. Let it be considered and totally it can be disposed of. Let me.
Lordship can take the report on record.
Correct. I am
I've
taking
given.
it. I
I've
will
given
dispose
it.
of it.
All the three accounts,
I will
all
take.
details are
That's
there.
why I asked for, because if it is second, I will take care of it and I will dispose of as it is with regard to the release of that.
Very good. And my lord, he has not said anything. He has paid almost everything. My lord, I would request, my lord, other than the initial remuneration, nothing was given.
I will take.
He will just lordship will kindly consider.
Absolutely.
If I may make just one submission.
Duty to explain express it. The originals are there.
Yes.
If I may make just one submission, if my learned friend is taking 2 weeks' time and the report receivers come, if we may be permitted to have a copy of the report, and in case and then after that we can file our written note so that if we need to address something there, we can have a look at that also, take the benefit of that. If it's anyway going up for 2 weeks.
That's right. Gorani, what you file regarding the report?
Only
code
that is between the
whether
court
the amount
and
is there or not, and nothing. You already argued on that.
We have already argued. So I'll leave it to the honorable court. We are ready with our notes.
Counsel for the objectors have filed their written notes of argument. Full stop. Counsel for the decree holder press for 2 weeks time. Accordingly, time to file written notes of argument by the petitioner / decree holder is extended for 2 weeks. Let the matter appear on 19th August for filing written notes of argument. By
kindly take the report on record.
The Learned counsel for the receiver has filed the report in seal cover. Let the same be kept with
Could it be the following week? Because on 19th, I'm already held up in Bombay. I'll be in the flight. I wanted to log in. Could it be the following week?
19th, 20th.
20th is convenient. 20th, or the court may just take, if it's possible, on 26th, 25th, 26th, 26th August, if that's convenient.
26. Okay, 26 has to be.
Very well. My learned friend's convenience. I have no problem.
Deeply obliged.
26th.
Deeply obliged.
Thank you. Thank you. Yes. Who has filed the wakalatnama?
Aditya Datta.
You are appearing for?
Defendant.
I appear on behalf of the plaintiff, your lordship.
The
plaintiff, your lordship.
The Aditya Datta filed on behalf of the defendant.
Yes.
So, why you not taken the no objection?
Yes, my lord. No objection has been filed also, my lord.
When?
While filing the wakalatnama. Because unless I file the NOC, the new wakalatnama will not be allowed to be filed.
And the wakalatnama filed without at the time the suit is parted. Yes, what is the problem?
Now, what happens, my lord, while filing the GS, we file a wakalatnama along with the NOCs. The GS are on board, lordship has heard and disposed of the application. Now, if you wanted to file an order 7 ruling application, we have been asked to file a fresh wakalatnama.
So you are having the wakalatnama in the suit.
No, mistakenly it has been filed in the GA.
That is the problem. If you are not filed in the suit, so every time then you have to file the wakalatnama. Then you have to file the wakalatnama in the suit.
That is mistakenly, but it is connected
Because
with the main suit.
I find here some of the GS filing by some other advocates
but
by fresh wakalatnama. But the court has to and the office has to see who is in the advocate on record in the suit.
So we have to get another NOC from the erstwhile
In the suit.
In the suit.
And
then again file a fresh.
Then you file this in that because that was in the GA, it has gone. Because once the GA disposed of, GA record is not with the department.
Right.
And the suit will remain in the department till the disposal. That is the problem. So what do you want to say?
But I don't find Millard because the erstwhile advocate will be again Millard to bother that if lordships can grant me leave for this time. There is only difficulty.
The matter is listed as to be mentioned on receipt of the report from the section officer of the suit registry department of original site. It is fine from the report that the learned advocate on record has filed wakalatnama in the suit without obtaining NOC and no objection from the erstwhile advocate. Learned advocate on record submits that initially they have obtained the no objection at the time of filing general application number
1, 2, 3. 1, 2, and 3.
1, GA number 1, GA number 2, and GA number 3. And all the applications have been disposed of. But now the present advocate on record is intending to appear in the suit. And it is not possible it is not possible for them to take a fresh no objection from the erstwhile advocate and place for acceptance of the wakalatnama. In view of the submission made by the advocate on record of the present advocate on record of the instant suit, the department is directed to accept the wakalatnama filed on behalf of the plaintiff, affirmed on behalf of the plaintiff on defendant on 14th May. On 14th May 2020. In the suit. Okay. Yes, next.
Great.
I appear for the plaintiff in this matter, my lord. Your lordship will recall on the last occasion, my lord, on 16th of April, your lordship had passed an order directing the defendants to take steps for completion of the evidence. My lord, on that occasion, they had stated that they have 2 more witnesses. My lord, both the witnesses have been examined. I think on the last occasion, we prayed for 1 day's extension, which was disallowed, and we carried out the examination from 3 o'clock to 6 o'clock, my lord, and that was completed. My lord, today the report was to be filed, which could not be filed. I believe the witness could not sign that. because the evidence recording continued after up to 6:30. From 2 to 6:30, then it had to be transcribed and then he had to sign it. I think he has left. And that is why on the last occasion we had apprehending that I had prayed for 1 day's extension, my lord, which was opposed by my learned friend. Now, my lord, they are seeking time to extend. My lord, it has to be extended because he has not been able to sign. But my lord, what I have come to know from my learned friend, they again intend to bring another witness. My lord, their witness, when they gave their list of witnesses, my lord, there was 3. One was struck out, the last witness, which was examined. And now again, in the order also, they said they have 2 more witnesses. Now they are saying they want to bring in another witness. My lord,
Yes,
it
but
is
may I-
dragging.
There are 2 parts of the report, my lord. May I just submit? My lord, will kindly take, this is the report on which CFSL report upon which the insurance company had repudiated the claim. Now, if my lord comes to page 1 and 2 of the report, 1, 2, and 3 of the report, this is the part which is for chemical testing. And the witness who was the director of CFSL Bhopal has come and proved these 3 papers. Now we find, my lord, will kindly take the next page. Now we find that there is a spot inspection report. Now, my lord, this was the spot inspection was conducted. My lord, will now kindly come to the last page of the report. This was conducted by 3 persons. At the bottom, Kollol Shil, Subhashish Mukherjee, and Sondip Patro. Now, my lord, the witness who had come, the director, the present director of CFSL Bhopal, has specifically stated that he won't be able to submit on this part of the report. So, my lord, we intend to call my lord Kollol Shil, who is presently.
What was the act of the director?
My lord,
You are examined the director CFSL.
Yes, my lord. The CFSL
Only for the
Bhopal,
report.
Only for his part. My lord, there are 2 parts.
What is his part?
My lord, the chemical testing part. My lord, will kindly come to the first page and the second page of the report. This is the chemical testing part which he has done through the samples, which he has, which under his instructions and the CFSL's Kolkata instruction was collected from the fire incident site, and
No,
he has proved it.
This chemical, who has collected the chemical?
My lord, these.
Who has collected the chemical?
My lord, the chemical was collected by Kollol Shil, Subhash Mukherjee, and Sondip Patro. The last page.
Correct.
And this Orgo Bandyopadhyay, who has signed the report.
Correct.
Now, my lord, we intend to call Kollol Shil, who is directly in CFSL Calcutta. He is presently the senior scientist B category for explosive. We are able to ascertain it. Now, my lord, this witness is being called, is required for proving this part of the report, the spot visit part of the report. This is why, my lord, we intend to call him, because the director who had been examined has specifically stated that he will not be able to comment on this part because this was not within his domain.
Naturally, how he can? He is only confined to this report. He cannot go beyond that.
Yes,
he cannot go
so, my
beyond
lord, we are taking steps. We will call him through subpoena, my lord. I'm being instructed that we have to call him through subpoena.
So, but you have not given the list of witnesses. The list of witnesses is over. If you want to additional witness, there is a procedure.
I'm told that officer of CFSL was there.
My lord, there were 3 in the copy that was served upon us. The last witness's name was there, which was struck off. My lord, I have this copy. My learned friend may deny that. I don't know, but this is the copy which I received. My lord, be that as it may, is it my learned friend's case that it is for the first time they have come to know that they have to bring another witness for spot verification proof? This is a commercial suit, my lord.
Correct. You have given the 3 with name, Center Forensic Science Laboratory that examined.
My lord, I'm being led by Mr. Sharma.
We have seen, your lordship, the list of witness, your lordship, because we were at the dilemma that who will actually do it, because there are 3 parts. One, your lordship, is the director who has forwarded it, and he has retired. The second one, your lordship, Mr. Boyjanti Mukhopadhyay, that's the second part. And the third part, your lordship, is the report of the spot visit. That's the only problem. Otherwise, your lordship, that particular witness, I specifically asked him, can you depose? He said that I am not the author of the document, so I can't adduce in connection with this particular report. So that's why, your lordship, we intend to only one, your lordship, witness from the CFS.
My lord, if your lordship allows me, the report that was handed over to your lordship, my lord, clearly states, the covering letter clearly states who can prove which part of the report. The defendants were clearly aware. First page, my lord.
That's my witness, your lordship. If I want to call him, your lordship,
yes,
through subpoena.
In a commercial suit, you have to take your call at the very initial stage.
That's not a mandate, your lordship. That's a procedural part, your lordship. If your lordship thinks, I will take out an application, your lordship. I think, your lordship, the name has not been specifically given in the list of witness. So, your lordship, that particular liberty, your lordship, kindly.
My lord, I don't stand in the way. The only thing I want to bring before the to the notice of this court is that they are deliberately trying to delay. My lord, on the last occasion, on consent of my learned friend, I prayed for 1 day's extension. I had not taken any the adjournment.
Allegation on us that we are trying to delay.
My lord,
is not correct.
Upon consent being taken from my learned,
we have not taken any
and they had objected
every
in
time
court.
Is allegation on the insurance company.
It so turned out, my lord, they were unable to complete the evidence.
Because we brought
by signing
that particular witness, your lordship, so that the entirety can be done. But now, your lordship,
it's just a delayed act is being taken by the defendant.
To whom you want to examine?
Yes, your lordship, Mr. Kollol Seal, because
lordship will make it time bound.
Yes, your lordship, we don't have any problem, your lordship. Time bound, whenever your lordship thinks fit, your lordship will issue the subpoena, your lordship, and that particular person, your lordship, can come down, your lordship, no problem. And whenever your lordship, the date
kindly,
has my learned friend come with the application for subpoena today?
We'll do it, your lordship. We are taking
Why?
steps.
He was aware. He was aware. If he is diligent enough, he should have come with the subpoena application today.
So I'll take steps, your lordship, within 2 or 3 days, your lordship, and I'll do it, your lordship. Okay.
Okay, you come with an application, serve the copy.
We'll serve the copy of the application.
ये दे दो उनको.
My lord, I will pay before your lordship. Your lordship keeps it on Wednesday or Thursday. By that time, the application should be filed, my lord. Otherwise, my learned friend will take more time.
The matter is listed as to be mentioned. For filing a report, but the learned counsel for the defendant submitted the defendant intend to examine further witness. Police counsel for the defendant prays for time for taking appropriate steps for examining another witness. In view of the submission made by the counsel for the defendant, case is adjourned. Let the matter appear on 8th August.
8th August.
In the meantime, my lord, the deposition of the last witness has to be completed, signed and filed.
I've suggested Mr. Chaudhary, if he gives your lordship, we'll send it to Bhopal and he'll make his signature and return us, your lordship. Otherwise, again, what the person has to come here in Kolkata.
He has to. That is why I mentioned.
No,
and it was objected.
In original side,
no,
what happened?
Cannot be done.
No, in that case, no. The electronics media, in that case, what he wanted to send, give the copy to both the parties, and the same copy be sent to, and he will not sign. He will buy an emails and
confirm
it. Confirm. He will
because in lower courts, your lordship, the person has to sign it, but in high court,
as per the evidence of the online, it is the same. He will only confirm through the mail that it is true and correct.
That has to be served on us as
That's why. So you cannot blame him, and he cannot. So what the commissioner wanted to send to the witness, both the copy be served both the parties, and the same copy be sent to.
It has to be recorded by way of an order, my lord, so that later on my learned friend cannot take.
Later on, I can take many points. So kindly
and that this is not
submitted by the learned counsel for the respective parties. That on which date the witness was examined? Director CFS Bhopal.
Last Friday, koto tarik chilo.
When
29th, my lord.
29th. Last happened on 29th.
28th and 29th was the last.
28th and 29th of July 2025. Director CFS Bhopal was examined, but the deposition could not be signed by the witness. Accordingly, the commissioner is directed to serve the copy of the deposition to both the parties, to the learned advocate appearing for both the parties, and the same deposition original be sent to the witness through mail, and the witness and after going through the said deposition, if the witness confirms, the witness will by way of email confirm that the statement is correct, true and correct. The statement made by the witness on 29th and 28th and 29th July is true and correct.
In the event, my lord, I'm putting a question to myself. In the event, the witness,
if it is dispute, then he has to
come.
If it dispute, then he has to and communicate the same by email to the commissioner.
Deeply obliged.
Actually, instead of 8th, can it be taken on 11th, Your Lordship? Friday and Monday, Your Lordship.
In 11th, correct.
I'm grateful.
Just the delay, how they are step by step.
Yes, next.
My lord, I am appearing for the defendant in the matter. This has come up at the instance of the plaintiff. It was mentioned.
Lord, I appear for the plaintiff, my lord. As per the last order, my lord, the parties have undertaken the exercise of discovery and inspection, my lord. I have prepared my admission and denial.
My lord, I have prepared my admission denial. Unfortunately, I'm told that the original is getting affirmed today. But
I am filing it, my lord.
I'm also giving a copy to my learned friend.
What about the suggested issues?
My lord, suggested issues, what
Prepared
she
the
has
suggested-
prepared, my lord, I am agreeable to it, my lord.
My lord, so far as the affidavit of admission denial which has been handed over to your lordship, I find that this is not done as per the Commercial Code
Code
Act,
Act.
because under Order 11 Rule 4, there are too many things which are required to be mentioned, but it's only as per the regular suit, whatever.
Lord, I'll agree on that, my lord, that it is.
So let it be rectified and.
Lord, I can, Lord, if my learned friend is agreeable, my lord, parties have undertaken the exercise of discovery inspection. I can mention these requirements in my affidavit of evidence. My lord,
No.
these
As per
particulars.
law.
It's
Very well, then I shall.
Even your this will not accepted by the department.
Then, Lord, I shall file it, but your lordship may give
When
me.
you will file?
I can file it, my lord, in a day or two.
Let the matter come. I am not recording. Come on.
My lord, so far as the suggested issues are concerned, I'm carrying the copy
Lord,
of the
her
suggested
affidavit of admission denial can be has been
My
filed. That can
original
be
is not
recorded.
filed. My original
not
is
filed
not
the
filed.
original.
I have only handed over an advance copy to my learned friend. So, but
Where is your
regarding the
suggested
suggested
issues?
issues, I have already
The
given
suggested issues which she has prepared, I am agreeable.
my learned friend.
Then I
is
can
agreed.
come on that day, my lord, when my corrected affidavit of admission denial is there. I will hand up.
My lord, what I propose is, if it commences to your lordship, because both the parties are ad idem regarding the issues, your lordship can formulate the issues as I have suggested. But regarding the completion of admission denial, because the exercise otherwise have been undertaken, we will have it exchanged amongst ourselves. I'm taking the advance copy from him. He can also accept the advance copy. On the next day, we will be filing our original admission denial before your lordship. But the issues may be formulated today.
আজকে করবেন, let the affidavit of admission denial be.
হয়ে যাক, আমি তো দিয়ে দিলাম copy. তুই তো
So in the meantime, I am fixing for witness access.
Yes,
Yes, my lord. Yes, my lord.
And in the meantime, you exchange your affidavit.
Affidavit of admission denial on that day we shall file it before the court. Yes, my lord.
And I am. You are agreeing with this suggestion?
Yes, my lord. I am agreeing with this.
The written statement.
Lord, just one more issue I think will be added, whether the parties are entitled to any further orders, if any. That last order, that last general issue that we bring, is not there. That is why.
Not required. Your suit is for money degree. That's enough.
I have an order to rule to leave.
That's for another proceeding. Sleep take to near the
আমাকে বলছে যে
Counsel for the parties prays for extension of time to file affidavit of admission and denial of the document. Let the same be filed within 2 weeks from date after exchange of the same between the parties. Counsel for the defendant has filed suggested issues. Full stop. Counsel for the plaintiff submits that he is agreeing with the suggested issues of the defendant. Considering the submission made by the counsel for the respective parties, peruse the suggested issues and the pleadings, comma, the following issues are framed.
মনে রাখতে হবে অ্যাডমিশন ডিনাইলটা কারেকশন করতে আপনার অ্যাডমিশন ডিনাইল
ওটা না আমি অ্যাডমিশন ডিনাইল this number
128. 128. This the police. The plaintiff is directed to file judge's brief of document.
Judge's brief of documents.
How much time?
2 weeks, my lord. By 2 weeks we'll file. 2 weeks হয়ে যাবে তো
By 4 weeks.
3 weeks, my lord, made with 3 weeks. 4 weeks.
Police to affidavit of document, affidavit of evidence of the plaintiff witness be filed within week thereafter. This is the matter. Give the date. 22nd September at 2 p.m. for
Yes,
witness action.
Extremely great. On that day we shall file our ওটা দিয়ে দিন তো
22nd September.
রেডি
Great.
Well, I am for the defendant.
Yes.
By application for
Amendment to file an additional note.
Well, one indulgence I am seeking, my lord. Well, I will just go through that. If well, we want to file, well, it is necessary to file, well, 1 pager or 2 pager, well, we will do that
Not
by
cited
Friday.
any judgments, nothing new.
You filed your written notes?
They have already filed their return.
We have filed all. I mean, one indulgence till Friday, my lord. If it is necessary, we will file, my lord, 2 pages. We have already filed. We have given them our note also.
Plaintiff has filed the additional notes of argument. Have you served?
Yes, I have served.
After serving the copy to the land counsel for the defendant. Counsel for the defendant prays for 2 days time to file
an additional
notes of argument, if any.
Lordship.
Let the matter appear on 8th of August and to be mentioned under the heading to be mentioned.
Lordship.
For filing additional notes of argument by the defendant, if any.
Lordship, I'm grateful. Watch it.
Next.
I appear for the plaintiff petitioner. My lord, will recall, my lord, on the last occasion there was some. So that amount was not tallying, my lord, will recall.
Not higher. So 1 is 12 lakhs.
Yes, 13 lakhs thereafter.
Then another one 13 lakhs.
13 lakhs and 15 lakhs is a fixed deposit.
15 lakhs, that is
fixed deposit.
District Cooperative Bank Limited.
Yes.
These
My
are the
lord,
three.
my lord, only one submission, my lord, substantial delay in compliance with the order. Will kindly consider. I leave it up to my lord. 30th August 2024 was the order under contempt.
इसके बाद आएगा DDR number the 2nd May 2025, maturity date is 6th June. June 2026. Full stop. The DLH Contempt has also deposited rupees 13 lakhs, which is invested by the registrar in the fixed deposit receipt number 885154 of Central Bank dated 5th July 2025 and maturity date is 6th July 2025. And the alleged contemner has also deposited the fixed deposit under the reinvestment plan receipt of District Cooperative Bank Limited for an amount of 15 lakhs and 15 lakhs and the maturity amount is rupees 16,09369 and the maturity date is 11th of February 2026. As the defendant has deposited the total amount of 40 lakhs.
40 lakhs, my lord, all these amounts come.
40 lakhs. Thus, full stop. 40 lakhs. Thus, this court did not find any reason to keep the present contempt application pending. Accordingly, CC Com 4 of 2025 is disposed of.
My lord, on delay, if my lord will kindly consider, that's up to my lord. It's between the contemner and my lord. I don't have much to say.
Yes,
Obliged.
कंप्लीट होता है आज का डेट में
Obliged.
ठीक है
Lord, item number 11, my lord, I am for the plaintiff. My lord, in this matter, on June 10, your lordship granted me leave to file a supplementary affidavit, my lord. My lord, we have received the certified copy on a belated stage. It is being affirmed today. If your lordship kindly take it up tomorrow, my lord, instead of today, my lord.
Not today.
Great.
Next.
I was appearing for the defendants, my lord, in this matter.
Yes.
My lord, here, my lord, we had filed a section 10. Taking the point that this is not a commercial dispute. Well, it's on similar lines as Deepak Polymer, but now with T. Thompson, well, I might have to reconsider that issue. There is also another application, well, which is for leave to file my written statement. I'm out of time. Well, at that, I know, well, your lordship's practice is different. At that time, it was before Justice Mukherjee, and it was his lordship's pleasure, well, to observe. Well, in fact, there is an order to that effect that well, this application may be kept in abeyance till disposal of the section 10.
Which one?
Well, that I think is GA5.
Well,
Well,
GA
today I'm in slightly
Well, I'll just indicate your lordship.
handicapped position because my
I'll
advocate on
assist.
record is not there.
My lord, I'll assist your lordship. GA3 is my learned senior friend's application. My lord, Order 7, Rule 11 application, your lordship. My lord, praying for dispense, my lord, revocation of the leave granted under 12A. Now, GA3 is their application. GA4 is also, my lord, their application, praying, condoning delay, my lord, praying for condonation of delay to file the written statement, my lord.
GA4?
GA4.
No.
Yes, my lord. GA4 is their application, my lord.
GA4 is the decree plaintiff press for leave for dispensing. अच्छा CS GA4 का है GA का है ऐसा कोई GA नहीं है
And my lord, GA5 is my application.
Let me see.
Yes, my lord.
GA4 is?
GA4 is their application, my lord, seeking the liberty of this honorable court to condone the delay in filing the written statement, my lord.
Yes, 68 days.
Lord, I am being led by Mr. Passman.
Yes.
I believe, my lord, it was filed within the outer limit.
Where is the written statement? You filed?
It is ready, my lord. It is affirmed, but because
No, it is not filed in the department. Then
I indicated to your lordship, my lord, that time it was pending before Justice Mukherjee. There is an order. I've seen that order. That this application be kept in abeyance till disposal of GA3, which was, my lord, my application for return of plaint. And, my lord, GA5 is their application, my lord, for summary judgment, injunctions, and special officer, where they are enjoying an interim order. I am paying rent. I've paid the arrears also. From month to month, I'm paying, my lord, at the last accepted rate together with accretions. I was only praying, my lord, may I come back? I'll just reconsider, my lord, T. Thompson and its implications on my case. Because, my lord, that was one of the points. I have another point also, that this being an educational institution, because they are running a primary school, this, my lord, would perhaps not be, my lord, within the expression trade or commerce under commercial code side. My lord, your lordship will kindly allow me a week's time. I'll come back sometime next week, my lord, and I'll be ready, my lord. These are two issues.
Yes, Mr. Basu.
My lord, as on date, there are 3 applications, 2 by them, 1 by us. Essentially, my lord, our application is in the nature of demurrer, my lord, that to, my lord, get the position. It is an admitted fact, my lord, that
They are in
my lord, the occupation and admitted is there is a defaulter. And they committed, my lord, additional alteration. Now, so far as their application is concerned, one, as it luminous, my lord, they say that they have affirmed, but nothing has been filed so far as any written version is concerned. Now, whether that application is to be allowed or not, that of course, my lord, will depend on the merit and subject to my lord's kind wisdom. I do not know what has happened and what is there, my lord, what my learned friend is saying. So for the next application is concerned, that is, my lord, that according to them, the plaint has to be returned because it will not fall within the domain of the commercial division. Now, that application is kept pending. So far the interim orders are concerned, my lord, that is, so far IA 1 is concerned, that was an injunction that was disposed uncontested. Initially, an ad interim order was passed. Despite service, they did choose not to appear. Thereafter, my lord, uncontested, Justice Kapoor has confirmed the interim order, restraining them not to alienate the property. Now, my lord, so far as on date, we are in limbo, my lord, we could not enjoy the property. My lord, she has been running a school, enter property in Shambajar More, in a North Calcutta. Lordship has gone to Shambajar More. It's nothing, something like Gorihat More in South, Shambajar More in North, and in the prime location, an entire building, 3-storied building, my lord, she has been enjoying since 2001.
Yes, social cause.
Payment of rent.
Well, that she says, social cause.
Accepting rent.
That is without prejudice. My learned friend should have gone through the cost papers correctly. If he says that I am accepting, that is without prejudice. I believe
an order of court.
Without prejudice.
Okay, okay. What? When you will come?
Anytime next week,
Kindly, my lord, a shorter time, my lord, whenever it commences, my lord.
As per the prayer made by the counsel for the defendant, let the matter appear on 13th August for hearing of all the applications. Next.
My lord, it will remain under the same heading.
No.
Same.
New motion.
I beg to appear on behalf of the petitioner in IAGA com number 3. There was a direction for filing of affidavit.
My lord, may I file my opposition?
My affidavit in reply I have served.
My lord, you kindly
Fixes up a date. Your Lordship.
for hearing, my lord, it's appearing under the motion, heading new motion.
Should be an
Under
adjourned
adjourned motion, we filed our affidavits.
What application? GA3?
For disclosure of further documents, my lord.
No, Your Lordship, my contention is that some documents were already there in the plaint. Those were mistakenly annexed. I want to bring the correct documents on.
You are for the defendant.
I am for the plaintiff.
I am for the defendant.
And counsel for the parties have filed their affidavit and affidavit in reply. Let the in connection with GA3 of 2025. Let the same be kept with the record. This is the matter on 20th August for hearing of GA3 under the heading adjourned motion.
I am grateful to Your Lordship.
14, my lord, I appear for the plaintiff. There are 2 applications listed, my lord. GA1 is my application for judgment on admission as well as security. This is where the original order of 30th August was passed, which is part of the contempt matter. The MLR affidavits are complete. The other application that's been filed by the defendant for acceptance of the written statement, Muller had called for a report from the department. It is certified today that no written statement has been filed before this court, even after much after expiry of 120 days. Well, it's for them to place that application. Well, that application we've not used an affidavit. We don't intend to. Well, it's a point of law. We'll argue it from the bar. So it's for them to place their application, and Muller can thereafter take up GA1 whenever it deems fit. Muller, we can place our case today as well.
Yes, madam. You have not filed written statement.
Your Lordship, I'm being led by my senior Ritoban Sarkar. He's
Huh?
on his. I'm being led by my senior Ritoban Sarkar. He's
Ah.
on his legs before another court. Your Lordship, kindly keep it not today.
No, but where is your written statement? You stated that you filed the
It's
written
not-
statement. That
no,
is
no,
not in the
it's not filed.
department.
That's been certified. I think, Muller, the point of law, perhaps they'll try to argue.
If it is not written statement, then I have to dispose this. You are filing an application.
Yes.
Which application?
GA3, I think.
GA?
Will give me one.
GA2.
GA2. GA2, Muller. For acceptance of the written statement, they filed this application, Muller, within the 120th day, but they didn't file the written statement.
Then?
Application was filed within 120, but not the written statement.
There's no written statement. You not file the written statement, how the time can be extended? When your senior will come?
Lordship, tomorrow.
Tomorrow. Not today.
Right, for your Lordship.
But I appear for the plaintiff. Well, there was a confusion with regarding the defendant's filing, date of filing of the written statement.
Milord 15, Milord, I appear for the defendant, Milord. I have, Milord, in my GA3, Milord, that is for the recalling of the order dated 30th April. Milord, in page 108 and 109, Milord will find that I have filed my written statement before the learned master on 10th March. That is within the 120 days period, Milord.
यार ये लोग सब पागल हो गए। यहाँ से सबमिट करता वाला रिटर्न स्टेटमेंट कहाँ में जाता? फिर इन लोग को उल्टा सीधा क्यों रिपोर्ट दे रहे हैं? तो ज्यादा इंग्लिश पढ़ने लगे तो बैठा दूंगा मैं यहाँ लाके।
Page 110, Milord, is the report given by the learned registrar.
GA3 है क्या? फिर कैसा बोलता GA3 नहीं है? कि क्या बोलता? Status report obtained from the CI so that there is no record of filing of GA3. ये कौन है फाइल किया रिपोर्ट? इन दोनों कौन है? तो ये कहाँ लिख क्या?
Great.
Before calling the fixed matter, the next matter, I intimated the lordship on Saturday. This is an application by the defendant to file the written statement. They have filed.
Hearing on behalf of the
My lord,
defendant, my lord.
my lord will not record my consent. My lord will do the needful. My lord can expedite the suit.
My lord, we have already filed the written statement well
Yes.
the time of 120 days, my lord. And for abandoned caution, we have also filed.
When you receive the writ of summons?
My lord, may I draw your attention to the last order dated?
I am asking the court is asking when you receive the writ of summons?
My lord, by post on 20th February and by bailiff on 15th February.
15th February. When you affirm the written statement?
My lord, it has been filed on June 10th June, my lord.
Written statement?
Yes, my lord.
10th June?
10th of June, my lord.
Where is the affidavit?
My lord, we have also filed an application.
You are also counterclaim?
My lord.
Counterclaim? You are also having the counterclaim
Yes,
or not? Have you filed the written statement in the department?
Yes, my lord.
Where is that?
Along
They seem to have taken leave from your lordship, my lord.
यार मन तो सबसे ना जो लीव देता हम लोग एक जेरक्स करके यहाँ रखो उन लोग को यहाँ से हम रिपोर्ट मांगे तो पूरा का पूरा डिपार्टमेंट घूमते रहते हाँ एक हाँ बैक सीट का एक जेरक्स करके हम लोग पास रखो Yes. Why you not filed?
My lord, we have filed, my lord.
No.
My lord, may I hand over my copy of the...
My lord, if they have received by post on 9th of February, then my lord, it's more than 120 days.
That's why I'm asking.
Yes.
No, 15th
My lord,
February.
15th No. That's by belief. But prior to that, they have received by
20th
post.
February and through postal services on 15th February, my lord. And my lord,
15th February.
120 days, we are...
Okay, come on next time. Okay.
My lord, may I pray for the acceptance of the written statement, my lord?
Come with the total details.
My lord,
You are-
we
you are
have the
confused.
details, my lord.
Yes, call the fixed matter.
Lordship, this is my application.
Yep.
Lordship would recall, this is the matter wherein the appeal court's order dated 6th of January, it was recorded, it was made CAV. Your Lordship recalls, your Lordship had passed an order on the last occasion. I had assured your Lordship that I will take steps to get that recording corrected. We had mentioned, and the Honorable Division Bench considered our, and they were in fact of the view that there might have been some error in the recording. So, Honorable Justice Shomenchen had directed us to file a suitable application. That application we have filed.
What application?
Application for rectification of that. If your Lordship takes your Lordship's last order once. Lordship will kindly see para 4. This court perused the judgment passed by the Honorable Appeal Court dated 6th of January 2025 in CS Com so and so.
Correct.
So we have taken appropriate steps and it has been elaborately considered.
So now what is remaining?
Now the remaining aspect is, your Lordship would recall, GA1 had been filed by me, the plaintiff, for judgment upon admission and other protective orders. GA2 was revocation of leave under clause 12, filed by the defendant. Thereafter, GA3 was filed for extension of time to file written statement.
Correct.
Now, GA3 was dismissed, GA2 was dismissed, GA1 and GA2 was dismissed by a common order.
Correct.
There are two analogous suits, CS 565 and CS Commercial 564 of 2024. Now, GA1 and GA2 were dismissed by a common order.
Correct.
Your Lordship had found that there is no case made out for revocation of leave.
Correct.
But since your Lordship was of the view that there might be a jurisdictional issue, a tribal issue regarding jurisdiction, at that stage, your Lordship had refrained from passing any order in GA1 on merits. That is insofar as GA1 and 2 is concerned. GA3 subsequently was dismissed. And their right to file written statement, the defendants, was closed. Accordingly, the suit was placed in the undefended list. But this application was never made ex parte. Now, there has been a change of advocate insofar as the defendants are concerned. And we have inquired, we have ascertained, no new advocate seeking to represent the defendant has filed their wakalatnama. Your Lordship, when your Lordship had taken up the suit, your Lordship had directed service to be effected on them once again. We sought to effect the service of the judge's brief of documents. That returned with remarks as, no such addressee found. Hence, return to sender. This is the status insofar as the defendant is concerned. They are not responsive at all. Subsequently, we have again, by email, served this judge's brief of document in the main suit, which has been made undefended. Now, all that is left in view of the order of the Honorable Appeal Court, Division Bench, dated 6th of January, is for GA1 to be disposed of on merits. And your Lordship would recall there are two matters. CS 565 of 2024, which GA1 in CS 565 of 2024 is today on list. Now, CS 564 of 2024 and the GA therein had an issue, your Lordship. Issue was, there was a discrepancy regarding the location of the registered office. Now, insofar as CS 565 is concerned, Shakambari, there is no such discrepancy. If your Lordship kindly takes the order of the Division Bench dated 6th of January 2025. I'll briefly just place that. Because what had happened, your Lordship, is while your Lordship were disposing of both applications together in both matters, before I come to kindly takes the order dated 6th of January. The appellant is, your Lordship has that order, 6th of January. The appellant is the plaintiff in a suit for recovery of money. Plaintiff filed an application being GA-Com 1, praying inter alia for judgment upon admission for a sum of rupees 3 crore 37 lakhs, along with interest at the rate of 24% per annum, order of injunction, so and so. The plaintiff filed the suit for recovery of sums due owing to reason of failure on the part of respondent to supply. As stated earlier, After hearing the application for judgment upon admission was concluded, an application for revocation under leave under clause 12 of the latest patent was filed. It is further argued that the point of jurisdiction was also urged in the affidavit of opposition filed in connection with the application for judgment upon admission. On the basis of the application for revocation, the basis of the application for revocation of leave under clause 12, that no part of the cause of action has arisen within the jurisdiction of this court. The defendant alleges that the defendant carries on business at Orissa outside the jurisdiction, the factory of plaintiff located at Purulia. All this is moot, your lordship, because your lordship has entered a finding and that finding has never been challenged. There were no cross appeals. So that has attained finality. 5. We have carefully read the plaint. For the purpose of the limited inquiry for leave under clause 12 of the latest patent, the following paragraphs are required to be looked at. Pursuant thereto, paras 4, 5, 27 of the plaint quoted. The bare reading of the aforesaid paragraphs would show, I'm now at para 6, your lordship. The bare reading of the aforesaid paragraphs would show that there is a clear averment that the discussion, negotiation, and agreement took place and or were concluded at the registered office of the plaintiff within the jurisdiction of the court. It is not in dispute that the address of plaintiff mentioned in the cause title is the place from where the plaintiff carries on business. It is the registered office of the plaintiff. Although, now, your lordship, at this point, I'll just pause. The confusion arose on account of this very paragraph in respect of the other suit. Because in Bravo, the other analogous suit, CS 564, the registered office at the relevant time when purchase order was issued was not within the jurisdiction. It was in Purulia. Your lordship had noted that. And because there was some discrepancy in para 4 and 5 of the plaint in relation to this, your lordship was of the view this needs clarification. But in Shakhambari, in CS 565, your lordship, there is no such confusion.
That's why come to the paragraph 15.
Yes, paragraph
15. In the impugned order, learned single
in
judge
the
is
impugned
mainly
order, the
focused-
learned single judge has mainly focused on the territorial jurisdiction of the court, although there are some discussion with regard to the claim of the plaintiff.
Correct.
The learned single judge did not take any prima facie view with regard to the prayer for judgment upon admission
Correct.
or injunction and declined to grant any relief on the ground that, having regard to the averments in the plaint and the nature of dispute raised by the defendant, the question of jurisdiction is required to be decided. Now, this was, may I read? May I just completely read it thereafter? The question of jurisdiction is required to be decided. The learned single judge, although has referred to coordinate bench in Parasram Harnand Rai, reported in AIR so-and-so, but while deciding the said issue, seems to have overlooked the ratio of the said decision, which clearly says that in an application for revocation of leave, the allegations of the plaint must be taken to be correct, and court will not enter into disputed questions of fact. Unless the application for revocation of leave under clause 12 of the latest patent is allowed, the court retains the jurisdiction to pass all interlocutory orders that may be necessary in the suit so that the plaintiff is not ultimately prejudiced. The defendant has failed in its application for revocation of clause 12 of the latest patent. There is no cross appeal. Prima facie, there is failure of consideration, there is no supply. The letter of defendant acknowledges substantial amount is lying with the defendant for supply of iron ore of the quantities and specification mentioned in the various purchase orders. Although an averment is made that the defendant is in a position to dispatch the iron ores, till date, no such dispatch was made with regard to any quantity of the balance iron ore. On such consideration, we direct the defendant to file an affidavit of assets in the interlocutory proceeding, disclosing all its properties having regard to unimpeachable claim for money, as it appears from communication dated 28th October 2021. Since the application for judgment upon admission and injunction was heard, and said matter was made CAV, this is the We request the learned single judge to decide the said application on merits until such time respondent shall not deal with his assets and properties without leave of the learned single judge. In the event security is furnished for an amount of 3 crore 37 lakhs, the embargo shall stand automatically vacated. We make it clear, shall decide the said application on merits without being influenced by the observations. The appeal of the application. So today, the entire confusion, your lordship, regarding jurisdiction arose because of
today what is to be decided?
Only the judgment upon admission.
Which application?
GA1. That is on board today. And your lordship had extensively heard it, recorded. And if your lordship kindly sees the order by which your lordship dismissed GA1 and GA2, that is the order dated, judgment dated 18th of November 2024. This is GACOM 1 of 2024, GACOM number 2 of 2024 in CS Commercial 565 of 2024.
GA1 is to be
Absolutely.
Yeah.
GA1 has to be disposed of.
Correct.
That's all.
Yes. Where is the GA1 now? GA1. This is a GA1. This is
GA1.
Okay.
In CS 565 of 2024.
Yes.
Your lordship had extensively, if your lordship kindly takes your lordship's order of judgment dated 18th of my apologies, 18th of November 2024.
Yes.
Paras 5, 6, 7, 9, 10. 9 and 10 are very important, your lordship.
Yes.
Your lordship had noted, however, despite receipt of the purchase orders and advance payments, the defendant did not make supplies on an ad hoc, basis, but was unable to supply materials corresponding to entire consideration received from time to time from the plaintiff. The defendant thereafter, by a letter dated 28th October 2021, stated that the principal amount of so-and-so along with interest accrued therein are lying with the defendant and assured that all iron ore will be dispatched to the plaintiff upon resumption of dispatches from the Sulepat iron ore mines. Despite assuring, so this is unequivocal liability, admission of liability. Despite assuring the plaintiff, the defendant failed and neglected to discharge its obligation by supplying materials. Subsequently, a meeting was held between the representatives of the plaintiff and the defendant on 21st September 2022, wherein defendant unequivocally assured that entire advanced amount which is due and payable by the defendant to the plaintiff shall be refunded within the period of 1 month, and in support to that, defendant further issued a notice dated 23rd September, wherein the defendant stated that soon after permission is received from the mining department, the defendant will supply the materials. Otherwise, the defendant shall refund the outstanding dues within a period of 1 month from the date of the letter. Thereafter, despite repeated requests, have failed to repay the amount to the plaintiff. The plaintiff then issued a demand notice, so and so. The defendant has now filed. Now, your lordship had in entirety considered on merits the contents of the application, my averments in the application.
Correct.
So today, all that is required is to dispose of that application on merits. Now, this is the only issue was, if your lordship kindly takes page 15, Page 15 of that order, your lordship's judgment of 18th of November, para 41.
Page 15, para 43.
Para
43.
Yes. Para 41, I'm referring to
page 15.
15. Internal page 15, your lordship.
Of the judgment.
Of the judgment. Para 41.
Achha. Yeah,
564. Nah, it's an important paper. Your lordship, entire confusion was because of the analogous matters. Actually, para 41 of 564 is correct. But para 41, with deepest of respect, your lordship will not take me amiss, categorically made out a case in paragraph that after negotiation and discussion, agreement was concluded in the office of the plaintiff, which is administrative office of the plaintiff situated within the jurisdiction of this court. But in the cost title, it is inadvertently mentioned as registered office instead of administrative office. Your lordship, these are the facts of 564.
Okay.
So in 565, there is no such admin office, registered office. Registered office is within.
Yes.
So now, in this background, your lordship will kindly take up my GA1. I'll straight away come to the basic documents in GA1.
Yes.
Your lordship will find the purchase orders from page 19 onwards. I will not labor upon the entire facts because your lordship is already conversant with the entire facts. The purchase orders were placed on and from 2000. Your lordship will kindly take page 20, for example.
20. Page 20, 20.
Page 20. My learned friend was requesting me to show your lordship's judgment up to para 12. I said I have already placed because your lordship had noted the facts. These are the purchase orders, your lordship.
Correct.
The purchase orders start from page 20 and continues. Your lordship will kindly take page 22, for example, just by way of illustration. Your lordship will kindly see purchase order placed by the plaintiff on the defendant, Virat Chandra Dagra. Your lordship will see delivery schedule. It's about 8th row from bottom. In the table, in the middle of the page, delivery schedule. Your lordship has found that?
Yes.
Immediate. Invoicing details, so and so, correspondence address. We hope you will find the above in order and will arrange to obtain mining permission for the ordered quantity immediately, enabling the dispatch of the material. Please send your invoice at Kolkata office.
So page 19 to 26.
Page 19 to page 26.
26 the invoices.
Invoices. This is one sample of the invoice.
Yes.
And your lordship, at the foot of the purchase order, your lordship will kindly find the registered office's Diamond Prestige, which is within the jurisdiction. Now, identical purchase order at 23. Now, your lordship will kindly take page 24, a slightly different format of the purchase order. I just want to show the understanding.
No, the 22 delivery schedule immediate.
Immediate.
Given by the to Dagra by the Sakambari.
Yes,
Correct?
plaintiff.
Okay. And
Now,
where is the registered office you mentioned?
Registered office at the footer of the page, at the foot of the purchase order. Registered office, Diamond Prestige, 41 A, AJC Bose Road.
Yes.
Kolkata 700017.
Then
Is within the jurisdiction. Now, your lordship will kindly take page 24 once.
yes.
Now, in payment terms, in the terms and conditions, all details of supplier, BC Dagra, delivery address, Shakambari, everything, billing address, everything is there. Payment terms, 100% advance.
Yes.
And delivery period, again, immediate.
Yes.
Lordship has seen that?
Yes, yes. Yes.
Immediate. Now, this is identical up to 26.
Correct.
Now, upon giving credit for everything, all supplies made from time to time and advance paid by me from time to time, there was a total outstanding balance insofar as the plaintiff in CS 565 is concerned of rupees 3 crore 37 lakhs. Now, this will be evident from the defendant's own letters at page 27. The typed copy is at 28. This is the letter which your lordship had noted in your lordship's judgment, 28th October 2021. Your lordship will kindly see the contents of this letter. To the director, Shakambari Ispat, Bravo Sponge. Dear sir, this is to inform you that principal amount of 6.20 crores on account of Bravo Sponge, we are not concerned with that at the present moment, and principal amount of 3.37 crores on account of Shakambari Ispat, plus interest accrued thereon, on all the advanced paid are lying with us.
So in this case, the 3 crore 37.
3 crore 37.
Not the 6.
Not. That is the subject matter of 564.
Yes.
We are pleased to inform you that we have leave received all necessary clearances to operate our Sulepat iron ore from various agencies, and we can start the dispatch. We wish to inform you that we have also applied for obtaining re-permission of so-and-so Bravo Sponge Limited, which is pending dispatch against earlier permission dated so-and-so. Now, third paragraph. We are in urgent need of some fund to start the mining operation and dispatches. We therefore request you to kindly arrange to transfer rupees 60 lakhs only as advance to us in addition to the above said advance.
So this 60 lakh is not here.
No, in this case, it is not relevant because Bravo had paid that 60 lakhs.
That 60 is not. And
Then bank
this
account,
is only
etc.
concerned with the 337.
337. Now, after that, your lordship will kindly turn over to page 29. And my contention is there is a unequivocal, unconditional admission of liability that additional sum of 3.37 I have not been able to supply and that I am liable to supply. So I'm willing to supply. But they have never supplied. Now kindly take page 29.
Yes.
The letter dated 23rd of September 2022. This is again addressed by the defendant to the plaintiff. Dear sir, with reference to our long outstanding dues towards your companies addressed above against supply of iron ore, I'm to say that a table discussion was held on 21st September 2022 in between Mr. Manish Agarwalji, Rohitji with Mr. BC Dagra and Mr. Devobroto Dagra at Radhika Resort, Bhubaneswar. As discussed earlier over this issue, please bear with us some more time. That is at least 1 month from the date of the letter for settlement of the matter. In the meantime, we are trying to seek dispatch permission from the government. Soon after permission is received from the mining department, we will supply you the materials as agreed earlier. Otherwise, this is the relevant portion. Otherwise, we shall refund the outstanding dues within a period of 1 month from the date of this letter. Now, supply admittedly was never made, and that was admitted in the opposition. And within 1 month, they did not pay the money as well. So in my humble submission, and the next line is also important, page 30. Further, I am to say that if I fail to supply or refund the amount as proposed, installment-wise payment will be done. So there is a categorical, my humble submission is, this letter dated 28th October 2021, read with 23rd September 2022, there is an unequivocal, unconditional and categorical admission regarding liability of outstanding sum of rupees 3.37.
Yes.
And a unequivocal undertaking to repay that amount within 1 month from 23rd of September 2023.
Yes.
And admittedly, neither has been done. So on this basis, I'm seeking a judgment upon admission. Now, your lordship will kindly take their affidavit in opposition. This affidavit in opposition, in my humble submission, point out to. And in their affidavit in opposition, your lordship, very interestingly, they admitted 3 things: receipt of the money, usage of the money, non-supply, and their failure to supply. And in fact, they had parallelly pleaded a case of frustration and ready and willing to deliver. Your lordship would recall.
Yes. ये वो affidavit का है? Affidavit in opposition का है?
I mean, lordship will kindly grant me.
report can. How this report has come? You are telling that no record of GH. This evident.
May I hand up?
Just a minute, just a minute. Application being number found it. When 30th July. When we have, I asked for the report when? Ah. That's why I'm asking. Okay. Yes.
Para 6, Your Lordship, of the opposition. Lordship has 6. It is stated that the instant suit as well as the said application has been filed with gross suppression of material facts. It is stated that all material time the respondent had binding lease over so and so. The respondent supplied several dispatches of iron ore consignments to the petitioner against purchase order, come tax invoice. The supplies so made were subject to permission as well. It is further stated that the supplies of consumer can only made after securing approval of transit, steel mines. Respondent have cleared it, so and so. Para 7. As on February 2018, there was no restriction to carry out transit and trade of iron ore stored at the mine premises. Company had made several visits to Sulepat iron ore lease between mine of the respondent lessee between December 2017 and February 2018 to inquire about modalities and logistics of respondent's mine before placing its first order. The respondent had made the petitioner fully aware of the transit permits that were required. It accordingly stated that it is causing dispatches of iron ore. Terms of the purchase order is subject to having the requisite permission to dispatch and trade. Such implied term is necessary for business efficacy, etc., etc. It is stated that the purchase order governing the juristic relationship did not contemplate charging of any interest, that the ledgers disclosed relevant period purportedly involving transaction forming part of the subject matter as well as the instant application does not contain or contemplate charging any interest. Lordship will kindly see the ledgers have not been disputed, only the interest has been disputed. And I'm today not on interest at all, I'm only on the principle. It has moreover been expressed understanding between the parties, no interest would be payable. Accordingly stated, petitioner is not entitled to any interest as alleged. No denial of the principle. It is stated that the transit permit, now very important, 9. It is stated that the transit permit of the respondent was stopped on 16th of April 2021. The respondent subsequently tendered several requests for permission for transit on 9th November 21, 12th November 21, even on 7th January 22, but the same was not granted. The respondent states that the last dispatch from its mine was made on 23rd July 2020 in relation to the request for transit made to the government of Orissa through its Steel and Mines Department is annexed here to and is denoted by letter R1. The respondent herein states that it has made and substantial investment for the purpose of securing necessary approvals for making such dispatches, and all the orders placed for delivery of the specified quantity of iron ore as contained in the purchase orders, but part of which could not be dispatched for not securing transit permit as lying in the Sulepat mine of the respondent, as would be evident from photographs taken from the mine site as annexed here to and collectively and denoted by R2. Categorical admission that entire quantities have not been supplied. The respondent has done whatever is within its control and cannot be made liable for commission of acts beyond its control. Very well. The respondent has always fulfilled and is ready and willing to fulfill its obligation arising out of the said purchase orders. It is stated that it is only due to transit and trade restrictions imposed by the regulatory authority for the transit has prevented respondent from making necessary supplies in terms of. So there is categorical admission of failure to supply. Now, very important, page 6, your lordship, it is accordingly stated that the agreement between the respondent and the petitioner herein stand frustrated. Now, your lordship, even if a plea of frustration is taken, my claim is not for damages. My claim is for refund of advance.
Yes.
So, a plea of frustration would tantamount to an admission of the liability to return my advance under Section 65 of the Contract Act. It is further stated, respondent cannot be held accountable for impossibility. All kinds of defenses. 12. Respondent has exercised due diligence, has taken necessary steps to secure necessary permission, but yet to secure the same despite making painstaking efforts and doing everything that is well within its control. It is stated, time was never of essence. It is stated, lordship, just one paragraph I want to show. Para 24, your lordship. Page 10.
Yes.
Kindly turns over to page 11, your lordship. About 5 lines from top. The respondent states, 1, 2, 3, 4, 5, 6. The 6th line. The respondent states that certain supplies could not be made in light of restrictions imposed by state government on transit of iron ore from the mines. The respondent had procured deliverable consignments from its mine, and the same was ready for transit at the relevant time, but was unable to cause dispatch during transit restriction. Unequivocal admission of inability to supply, failure to supply. The respondent had procured the deliverable consignments from its mine, and the same was ready for transit. It is stated that the advance amounts taken are required for undertaking mining operations such as drilling and excavating, which incur high expenditure. It is stated the consignments were all piled up but could not be dispatched owing to restrictions so imposed with no fault or liability on the part of the petitioner. The advance payments against purchase orders were levied whenever an order was placed so as to enable the respondent to operate its mine to get ready the deliverable iron ore, which involved substantial expenditure and not for making continuous delivery as alleged. The understanding was to have continuous flow of business but not to cumulatively adjusting all the advances. The advances were always demanded in terms of the specified quantity stated in the purchase order. It is denied and disputed there has been any neglect on the part of respondent to supply. The respondent cannot be said to be liable for acts beyond its control. Fine. In relation here to it is stated balance quantity of deliverable is lying accumulated at the iron ore mine. Same cannot be delivered on account of subsisting transit and trade restrictions. The respondent has utilized the advance received by it to mobilize the deliverables at the consignment which is accumulated at the subject mine. It is accordingly denied the respondent is liable to pay. All assurances made to the petitioners were subject to securing due approval. The respondent is not denying its obligation to make the balance supply, but is denying obligation to pay the alleged sum in view of the fact highlighted herein above.
Yes.
Now, one comment. This is completely contrary to the contents of the letter dated 28th October and 23rd, because that assurance was not made conditional upon any receipt of. It was said, if I can't procure within 1 month, then I will pay you. So there is no serious dispute to the fact that I had given advance, that the advance was lying with the defendant, that the defendant was unable to supply. that the defendant has appropriated and used my advance and it has never supplied. So in conspectus of these facts, your lordship, I was making a prayer for a judgment upon admission only to the extent of rupees 3.37, because that is what we are concerned with insofar as the plaintiff in CS 565 is concerned.
Yes.
And in support, your lordship, I could cite two judgments, Uttam Singh Duggal and Hari Steels, just for the proposition that once there is an unequivocal, unconditional admission as to a liability, then judgment upon admission can be passed.
Yes.
Para 11, 12, and 13 of
Uttam Singh
Duggal 2007 SCC 120. I have quoted these judgments too many times. Para 11, 12, and 13.
Yes.
Now, the proposition is that once there is an admission, there is an opportunity of explaining the admission has to be given. And if no explanation for the admission is given, then the court is within its power to direct an order, nature of judgment upon admission under Order 12, Rule 6. Now, here in the instant case, adequate opportunity was granted to the defendant to explain the contents of the letters dated 28th October and 23rd. And your lordship would recall that not a single sentence and no specific explanation of these two letters were made in the opposition. The only statement that was made at para 24, which I just placed, was that these were conditional assurances, which I'm stating is ex facie contrary to the contents of the letter themselves. The letters are not conditional. The letters do not say that if I get the permission, I will supply you, then I'm not liable. No, the letter says from 23rd of September, if I can't supply, then I will repay the money. So that is my submission. Uttam Singh Duggal copy है. My apologies, your lordship. I will hand up a copy of Uttam Singh Duggal in the course of the day. These are my submissions insofar as GA1 in CS.Com 565 of 2024 are concerned. These are my submissions. I'm not laboring upon repeating other judgments, and I'm also relying upon Rahul Shah. In the event your lordship feels that judgment upon admission is not to be granted, then at least will safeguard me. And I have made the pleadings because the license was cancelled. I had shown that the permission to operate the mine was cancelled, and they also admit that. And I had also shown various group companies were being struck off from time to time. I have made those pleadings, if your lordship, very quickly, just to point out. Page 44 onwards, your lordship. 45 onwards.
Yes.
45 onwards, your lordship will see Script Sole Financial Services, August 25, 2023. At page 46. Just pointing out.
Okay.
And the license that was cancelled, your lordship, that might be of some relevance. That is at page 61, 62, your lordship. Uttam Singh. Yes, your lordship. I have found Uttam Singh Duggal. I'm handling. Page 61, your lordship will kindly take. BC Dagra and Sons Private Limited, so and so. 62. Page 66. Current status Baripada, BC Dagra, lessee name BC Dagra, Sulepat. This is the Sulepat iron ore mines, current status. Page 66. This is as at 6th of March 2024. Page 67, your lordship, lessee current status non-working.
On.
Remark, mining operation has been suspended by Indian Bureau of Mines for non-compliance. Further necessary clearance from NBWL, CTO, SPCB approved mining plan from IBM is wanting from lessee.
Yes.
And in all the subsequent correspondences, all the subsequent pleadings that are filed in the instant proceeding, they have your lordship at time and again asked, have you received the permission? Are you in a position? Till date, they are not. So these are my submissions, your lordship. I'm deeply obliged.
Man appears on behalf of the defendant. Counsel for the plaintiff concluded his argument in connection with GA Comp 1 of 2024 for judgment upon admission. CF.
I'm deeply obliged, your lordship. I'm grateful.
Plus 17, my lord, my application. Look, this is an undefended suit where I have filed this application for disclosure of additional documents, my lord, because it's a commercial suit. I have to seek leave of this honorable court.
Why you not disclosed?
My lord, these are documents, my lord, which came to existence later, my lord, after filing of the plaint. My lord kindly sees that the original plaintiff.
When you filed the plaint.
My lord, the plaint was filed. It's a plaint of
Number
2021.
Number 21.
My lord, all of this, two of these documents, my lord, came to existence later.
Which
and
document?
My lord kindly comes to para 9, my lord, of my application. There are 3 documents, my lord, which I have indicated. My lord, I will explain the situation in which this came to pass, my lord. The original plaintiff number 3, my lord, he died. And after that, we had filed an application for substitution, my lord, that was done. Now, this so the first document, my lord, sees is a deed of reconstitution of the trust, my lord, in para 9, item number A of my application.
Page?
Para 9, page 4, my lord.
Para 9. Date of reconstitution.
My lord, this is subsequent to the death of the original plaintiff number 3, my lord. After that, my lord, the new trustees, my lord, have decided to appoint one Shri Srikanto Dolui, my lord, as a power of attorney holder to depose, my lord, on their behalf. My lord, that power of attorney has been disclosed at item number B. And item number C, my lord, is the appointment letter of this Mr. Srikanto Dolui, because otherwise, my lord, the original plaintiff number 3 was a person who had verified the plaint and he was supposed to depose. But because of his death, my lord, this new person, my lord, Mr. Srikanto Dolui, who had been appointed prior, he is well conversed with the facts and circumstances of the suit, my lord. He is now being, a power has been given in his favor by the present trustees, my lord, to depose in this suit. My lord, these are the 3 documents that I am seeking leave to disclose. The documents, my lord, start at page 13 of my application. And I have also annexed at page 27 a proposed amended list of documents, my lord. 3 documents, item number 6, 7, and 8.
Yes.
My lord, this is undefended, my lord. So this.
Nobody's appearing.
No, my lord, they're not appearing. Since the beginning, my lord, they've never appeared since 2021.
The plaintiff has filed the present application being GA Comp 6 of 2025, praying for leave to bring some additional document as mentioned in paragraph 9 within bracket A, B, and C of the instant application. Counsel for the plaintiff submit that the document which the plaintiff intend to bring on record are of after the filing of the suit, and as such, the said documents were not in possession of the plaintiff. Thus, the plaintiff intend to bring the said documents on record. He submits that the said documents are very much necessary for proper adjudication of the instant suit. Counsel for the plaintiff submit that After the death of the plaintiff number 3,
my lord.
her the legal heirs have been substituted now.
My lord, the present, it has been, substitution has been done, my
Legal
lord.
heirs of the defined plaintiff number 3 have been substituted.
Instead of Sudarshan Jalan, my lord, it's now Padmanabh Jalan.
And plaintiff number 3, the legal heirs of the plaintiff number 3 have been substituted. Full stop. After the death of the defendant plaintiff number 3, the deed of reconstitution of the trust was entered on 27th of November 2024, and thereafter on 9th of January 2024, one power of attorney was entered in favor of Srikanta Dowley, Dowley, to depose in the present suit.
In the present suit, ma'am.
To depose in the present suit, and also an order of and letter of appointment dated 1st April 2017 was issued by the trustees in favor of the Sukanta Dowley. But it is a letter of that Dowley.
My lord, because my lord Srikanta Dulu is now being deposed, my lord, his appointment letter is now.
But not the learned counsel for the plaintiff peruse the application in the document. This court find that the suit was filed on 22nd of November 2021, and subsequently on the same day, leave under section 12A of the Commercial Code was granted, and plaint was admitted subject to scrutiny by the department. This could find that the document which the plaintiff intend to bring on record as an additional document are of 27 November 2024 and 9th of January 2025. That is after the filing of the suit. One of the documents which the plaintiff intend to bring on record, that is the appointment letter of Mr. Dholi, Srikanta Dholi, is of 1st April 2017. That is prior to filing of the suit. But the said letter is connected with the power of attorney dated 9th of January 2025, wherein a power of attorney was executed in favor of Srikanta Dholi only on Srikanta Dholi. So considering the above, this could find that, and considering the above, prayer A and B of the instant application is allowed. GA Com 6 of 2025 disposed of.
I'm great.
Yes.
My application for acceptance of written statement. I'm for the defendant number 2.
My lord, I'm for the plaintiff. The lead counsel is on his legs. Kindly gives a short pass over my.
For acceptance of my written statement, I do not think.
When the writ of summons was served?
Writ of summons served on 19th of April 2025.
And when your written statement
affirmed on 9th of July 2025. Filed on 28th of July 2025. So there's a delay of 74 days.
From the filed in the department.
Lordship, the written statement is I'm carrying with me, Your Lordship. Lordship, I'll just show the affirmation.
April. 19th April. We have 120 days is over.
9th of July.
Maybe, but even 120 days is over.
No, Your Lordship. May, June, July, August.
August of?
19th August is
18th of August.
Lordship. This is affirmed on 9th of July, filed on 28th of July. So there's a delay from the original.
Application is filed.
Application is filed, Your Lordship. I'm carrying the written statement.
It's not been served upon us.
Application?
It has
You're not
been
served.
No, Lordship, I'll just check. Well, it's been served. In fact, my advocate on record is not here, but the track report is there.
Track, no, where is the track report? Only the receipt is there. Postal receipt is there, track report is not. Have you obtained track report?
No, Your Lordship, the track report is not there.
Serve the copy.
So I'll serve a copy. May I come back tomorrow, Your Lordship?
Tomorrow. The defendant, all defendants.
So I'm for the defendant number 2.
The defendant number 2 has filed the present application being GA Com 1 of 2025. 1 or 21?
1 of
1 of
2025.
2025. praying for extension of time to file return statement. Counsel for the plaintiff submitted the copy of the application is not served. The learned counsel for the defendant has served the copy of the application to the learned counsel appearing for the plaintiff. Let the matter appear tomorrow.
Great, Your Lordship. May I have a copy, the written statement, Your Lordship?
Return statement. Yes, next.
Great, Your Lordship.
Lord, this is
Lordship,
an
item
application
19, I
where, my lord, your lordship, my lord,
copyright suit.
my lord, where your lordship had, my lord, heard us, my lord, substantially. This is with regard to, my lord, Paresh Chandra, my lord, Dash. We, my lord, we, my lord, challenge the locus of, my lord, the plaintiff to file the
Settlement.
suit. Settlement was
settlement have
going on.
failed,
Now
what
they
I am
have
told.
failed. So your lordship, my lord, kindly, my lord, fix
Both
this.
were in
Any
reply, we were distinguishing
Lord,
the
I'll-
decisions cited by my learned
I'll
friend.
tell your lordship very frankly, my lord, it is almost been 6 months and odd, my lord, where we have, my lord, last argued the matter. So if your lordship kindly allows me to briefly, my lord, very briefly, my lord, recapitulate the matter, my lord, any day convenient to your lordship, and thereafter, my lord, comprehensive.
Why not today?
My lord, any day other than, my lord, today, my lord. Very briefly, my lord, we'll recapitulate the matter, and my lord, Mr. Ghosh can thereafter, my lord,
Distinguish the decisions.
and complete his submission.
ये क्या पाठन matter है क्या? As per prayer made by the counsel for the parties, is adjourned. Let the matter appear on.
My lord, any time may be fixed, my lord.
Then it will go September.
Very well, my lord, it will be there, my lord.
No problem.
Give the
No,
date.
let's fix the time. I don't
Fix
have
the
a
time.
Let a time
The
be
matter appear. At September 11:30 AM.
I'm great.
extremely grateful.
WhatsApp.
Lordship, item 20, I appear for the plaintiff. In this, talks of settlement have fructified and materialized. We are filing the terms of settlement. Yes.
Terms of settlement?
Yes. Terms of settlement. Joint? Yes. The dealership agreement. The parties have come to an understanding. The defendant has agreed to take dealership from the plaintiff. Let a copy. Jeta George ke dila. Copy dao bhai. Lordship would perhaps have to dispose of the injunction application.
The suit will be disposed.
Lordship, the suit is not with your lordship. It is being heard by Justice Kapoor.
Suit is not here.
Suit is not
Suit is
appearing,
here.
Lordship.
So how it can be done?
Yes, so Lordship would kindly dispose of the injunction application. The suit is appearing before Justice Kapoor. We shall place this before
So this
Justice
has to
Kapoor
be
and
placed in the. So what order?
Lordship, the injunction application is appearing before your Lordship because
so
that has
passing
been
an order.
marked
You're
as-
not pressing the injunction application in terms of
because the parties have settled the
settled between
disputes
the
and on
parties,
the
so
basis of
disposed
that,
of,
yes, the
that
suit
they
can be decreed by
that
my Lord Justice
you
Kapoor.
place before.
Yes, yes. Lordship passes necessary orders. Lordship would dispose of the injunction application.
Only one application is there, na?
Yes.
The plaintiff has filed an application being GA-1 of 2024. Initially, the plaintiff has prayed for ad interim injunction, but the same was refused and directed the parties to file affidavits. The parties have also filed the affidavit, have completed the pleadings. During the hearing of the injunction application, it is informed by the learned counsel for the respective parties that the parties have settled their disputes by entering into a dealership agreement on 4th of August 2025. In view of the above, GA-1 of 2024 is disposed of.
Yes.
The as regard, I am not, you mentioned the matter.
Certified copies.
Is there no?
But you would kindly direct urgent certified copies of this.
Yeah, you will get the order. Today itself you will get the order.
Great.
Hey. Eh? Eh?
My lord,
Yes.
in this matter, I am for the defendant, my lord.
Yes.
My lord, our witness is, my lord, suffering from high fever, my lord. My lord, more time accommodation may be.
Pay the cost.
My lord, this is, my lord, because of the season change. But the last occasion we appeared, my lord,
What can be done?
My instructions
January,
also.
June, the date is fixed. If your witness is not able to come, you
last
could have been informed.
they appeared, my lord.
Maybe.
My lord, one time, one accommodation, my lord.
What the court will do for the 1 hour?
My lord.
Fixed matter, nobody will appear before this court
I
now.
understand, my lord.
12:30 to 1:30.
Difficult condition, my lord, because of the, my lord, health issue. Otherwise, my lord, I would never ask for, my lord.
And every case, somebody got fracture, some got an accident, some is a heavy fever, some is a viral fever.
Maybe any date, my lord, any date, my
Any
lord.
date, how? Once
The
the
last
adjournment,
occasion, my
then
lord, I have never asked for, my lord. Last occasion we appeared, my lord. Yes,
Look,
yes.
there has been time sought on prior occasions as well. You know, my lord, orders will speak for themselves. Last occasion, the witness had appeared. Thereafter, again, time was sought.
No, not. Go through the record, not that. That is not the fact.
Apart from that, my lord, today, if my learned friends, my lord, say that the witness is in some difficult, let a commissioner be appointed. We don't stand in the way. That can be maybe appointed. We don't stand.
Cost maybe.
No, it's my learned senior friend's witness. Let them bear. It's the defendant's witness. Let that be appointed. I don't stand in the way. We will cross-examine, and my lord's time will not be wasted. My affidavit, my lord, or rather, my evidence was closed in January 2025.
It also sought time for accommodation, my lord, during their witness also.
No, subject to
That
correction,
is
my
not,
lord.
that is not
Subject to correction.
my
fixed matter, it is very difficult
my
matter
lord,
to
this is
contact.
not only for because but the last occasion we were
Okay, I'm
getting, my
fixing
lord.
September. You pay some cost to the High Court Legal Service Authority.
Nominal cost. I bowed out, my lord, what falls from your lordship.
By an order dated 20th June 2025, this court has especially fixed the matter with the consent of both the parties today for witness action. When the matter is called, common learned counsel for the defendant press for time and submit that the witness due to illness of the witness, the witness is not in a position to appear before this court. Considering the above, the case is adjourned. Let the matter appear on 22nd September at 3 p.m.
My lord, only pray, my lord. I don't stand in the way, my lord. Let this be a peremptory direction.
It
at
is
least.
made clear that on the date fixed,
Yes,
if the defendant failed to bring the witness, evidence on the side of the defendant will be closed.
Please, my lord. Okay.
Next.
Item 21 was my application for judgment upon admission. I had already placed my submissions.
Who is
Made
for
my
the other
submissions.
side?
Mr. Choyan Gupta was amidst his submissions. He was opposing and he was representing.
Nobody is there.
What I put it on record. Last order. Last order. Yes. Counsel for the plaintiff has concluded your last order, your lordship's
Yes,
order. 23rd July.
In your
Counsel for
submission
plaintiff
made
has
by the
concluded his
counsel.
arguments. I had already concluded my Learned Junior had addressed your lordship. Counsel for defendant has argued the matter, but he submits to make further submission. Mr. Gupta was to continue his submissions.
Where is Mr. Gupta? Not today. Not today. Next.
My lord, I am appearing for the petitioner's plaintiff.
Yes.
Reply to their
Petition for revocation of clause 12B. My lord, I have started my submission and I have placed, my lord, that paragraph 4, the plaint, we have pleaded our cause of action to be arisen within part of cause of action to be arisen within jurisdiction. My lord, just once we'd like to go through para 4.
Para 4 of?
Para 4 of the plaint.
Of the plaint.
My lord.
Yes.
It's their case that nothing has arisen within jurisdiction. Our case is part of cause of action, very much arise within jurisdiction, and the defendant issued a letter of intent dated 28/12/20 to the plaintiff, hereinafter referred to as the said LOI, letter of intent, for conversion of coking coal to be supplied by the defendant on a regular basis to the plaintiff into so and so through the coke plant operated by the plaintiff at Belur Industrial Area, Dharwad. The said LOI was signed by the plaintiff at its office at 46B Rafi Ahmed Kidwai Road within the jurisdiction of this honorable court, and the annexure to this effect will also show, my lord. May I take your lordship to annexure B, my lord? That is at page 31.
Yes.
My lord will see.
Page 31.
My lord, 31 annexure B. My lord will see that SLR Metallics has issued its LOI to the Kolkata office of Jeju Metal, which is at 46B Rafi Ahmed Kidwai Road within the jurisdiction of this honorable court, and it was to the attention of Mr. Ajay Kumar Singh, who is the MD of the company and sits and operates from Kolkata, the registered office. And our also case is this was signed at Kolkata by Mr. Ajay Singh, which they have later on carried to Dharwad, and the rest of the people have signed there. But Mr. Ajay Singh has signed this at Kolkata. My lord, my next paragraph is paragraph 31.
What is the date?
Pardon, my lord, this is the letter. Date of
execution?
Date of execution is, this is, my lord, before
28/12.
28/12 they received, and they went there after that. Before that, after receiving, he signed it in Kolkata. And my lord will come to page 31, my lord.
Yes.
Oh, sorry, my lord. Para 31 of the plaint. Para 31, page 12. Page 12 of the plaint, my lord.
Yes.
The cause of action partly arose on or about 1622.
Paragraph?
Paragraph 31, my lord. Page 12 of the plaint.
Print in close? No.
My lord, may
Yes.
My lord, the cause of action partly arose on or about 1622 at the plaintiff's place of business, that is unit so and so, within the jurisdiction aforesaid, and partly arose at defendant's place of business outside the jurisdiction. The honorable court has jurisdiction to try and entertain this suit. So the pleading is there, my lord, very much. And my lord, I will like to place page 42. Some of the mails, not all, my lord, some of the mails relevant for this purpose. Page 42, annexure F.
Of the plaint,
of the plaint.
42.
42, my lord. Annexure F.
Yes.
So, my lord, this again has been written by the MD Ajay Kumar Singh from Kolkata. Instruction to our plant, JPML, cold storage, etc., loading of coke, etc. And it is written to the defendant who is operating from there, Mr. Patil. My lord, I am not going through the content, my lord. I am just trying to show that how the part of cause of action has arisen within the. My lord will. And yes, my lord, the trail mail of this mail, it comes to next page at page 43, my lord. So again, it has been written by Mr. Ajay Kumar Singh to Mr. Patil regarding some shortage of coal and pushing of coal because the plant cannot remain idle, for which we constantly was reminding them for sending us coal which they were supposed to supply, my lord. My lord, page 44. Regarding JPML payment and lifting of SLR coke.
Yes.
This is being written by the defendant's person, B.V. Patil, and to Mr. Ajay Kumar Singh directly, with CC to others. Always, and as per dispatch details, they have given some calculations about the payment, which comes to 20 lakhs, and this has been addressed to again Mr. Ajay Kumar Singh at Kolkata. Annexure, so this was Annexure H. My lord will kindly come to page 47. Annexure J.
Yes.
So, my lord, again, Mr. Patil writes to Mr. Ajay Kumar Singh, who is the Jeju Metals MD. So, again, this is regarding plant operation, unrest, JPML DD, etc., amounting to rupees 38 crores. So, my lord, I am not going through the content again because I am on the cause of action, how it has arisen within jurisdiction. My lord, now, my lord, we have annexed the ledger of SLR, my lord, where it has been shown at page 55 and 56. All the payments has been received by Jeju at his Kolkata office and Kolkata branch. And it has been,
How you can say for Kolkata?
my lord, all the interdivision transaction, my lord, will go through the ledger, and it has been supported by our bank account details also, my lord. Interdivision transaction HO to Kolkata. And all the payments from opening balance to the end, all the payments in the ledger of SLR, it is shown that all the interdivision transaction has been happened to Kolkata. All the payments has been received by Jeju at Kolkata.
Oh. This is the account balance of ledger account of whom? Of the defendant.
Defendant, my lord.
Correct.
My lord, will come to, in this regard, I will request my lord to take up the affidavit in opposition to the petition, my lord, of Jeju. My lord. So, in our affidavit in opposition, my lord, we have also annexed the bank account details, which shows all the payments has been received by at Dalhousie, Kolkata Stephen House at our bank from
Where from your
the my lord, this is the page 11, annexure B of affidavit in opposition.
Correct. So how you say the
My lord,
statement of current account?
My lord, this will show that this all the payments of RTGS through RTGS or whatever we have received, my lord, all are in Kolkata, Kolkata Bank, my lord. Few pages have been annexed, my lord. All the payments we can show that it has been received in our bank in Kolkata.
Okay.
Few pages have been annexed here, just to corroborate our contention in the plaint. My lord, in this regard, my lord, we can take up the annexure 8, page 38 of revocation application, my lord, which they have annexed.
Yes.
My lord will see that again they have annexed the letter from Ajay Kumar Singh to Mr. B.V. Patil, which speaks about coke and coal lifting from JMPL. So most of the cause of action regarding the administrative, all
But
the
you want to show page 38?
because because this letter has been written from Mr. Ajay Kumar Singh from Kolkata to Mr. B.V. Patil. That is also written on September 27, 23, my lord. This has been written by Ajay Kumar Singh, which they have relied on, my lord. My lord, again, I am not going through the contents, my lord.
Yes. Yes.
My lord. Now, my lord, I am relying on a judgment of this court, my lord, passed by Honorable Justice Harish Tandon. Which করেছিস? হ্যাঁ, ঠিক আছে, রাখ, তোর কাছে আছে তো তোর। My lord, in this judgment, my lord, the application for revocation of leave granted under clause 12 has been dealt with. And in this judgment, my lord, Justice Harish Tandon has relied on several judgments of this court. Madan Lal Jalan, AIR 1949, Calcutta 495. And also Parasram Hiranandani versus Chintan Das. That also AIR 1952, Calcutta 82. Those has been considered by his lordship. And after Kanthal India versus Anand Prasad Bhatia, reported in AIR 1987, Calcutta 24. This has also been considered, my lord. My lord, at page 9, my lord.
Yes.
My lord, his lordship has now deduced the legal principles which appears from the above, all those above supra judgments, and these are like, I'm going through, my lord. that the application lies for revoking the leave granted under clause 12 of letter patent, that such an application should be made at an early stage of the suit, and delay and acquiescence may be a bar to such an application, my lord. On this point, my lord, I will like to place the case status, my lord. This case has been filed in 2022, wherein we have also prayed for interim order, which was granted, and then they have appeared. First, they did not receive the service, and thereafter they have appeared after again the service was made, and they have appeared and they have filed a vacating application in the year of
Appeared.
huh?
When they have appeared.
In 2022, my lord. And my lord, I will like to hand over the case status of this court only, wherein it appears they have appeared in 2022, they have contested to the vacating application, they have obtained an order in the vacating application, after which it appeared that the plant where the conversion was happening, it was actually of Gujarat Tannery, which went to liquidation, and thereafter it was handed over to the the officer, and we could not anyway have entered the plant, could not allow them to take away the conversion of the coke. So we could not, that prayer, actually our prayer was for appointment of receiver, that prayer finally became infructuous because the plant did not was under the official liquidator. And my lord, this is the case status, my lord, which will show they have thoroughly contested the suit by way of vacating application and appeared and got the vacating order. Everything has happened in 22, my lord.
Yes.
And thereafter, they have made this application for revocation, which my humble submission is totally afterthought, and it was at a very later stage, and now they are barred. If the application depends on difficult question of law or fact, the court should not revoke leave on summary application, but should decide the question at trial, my lord. My lord, here also the question of disputed facts are there, and we need to go into trial, my lord, to prove that, my lord. Hence, revocation of leave is not the solution, my lord. And my lord, I have also shown much of the part of cause of action has arisen within jurisdiction. My lord has every total complete jurisdiction to try this matter. That if the defendant shows clearly that no part of cause of action arose within jurisdiction, the leave can be should be revoked as a matter of course, my lord. We have shown that sufficient cause of action has arose within jurisdiction, and we are operating from Kolkata. And question number 3. That if only a part of cause of action arose within jurisdiction, then it is a question of discretion for the court, my lord, which the court has exercised after being satisfied, and the leave under clause 12 was granted. My lord, that the court may refuse that in giving or refusing leave or maintaining or revoking leave, the court will ordinarily take into consideration the balance of convenience and may, if the balance is definitely in favor of defendant, my lord, they could not prove any overwhelming balance of convenience in their favor, my lord. Not very voluminous documents are to be relied on, my lord. It can easily be tried under this jurisdiction. Hence, my lord, may my humble submission is I have already submitted before this court how the cause of action has arisen, my lord. So the defendant could not and failed to show that no part of cause of action has arose within this jurisdiction. The And also, my lord, I'm just repeating for the convenience, the defendant could not prove the balance of convenience is overwhelmingly in their favor. My lord, the most important part is, my lord, the defendants have not filed their written statement in spite of the order of this court that they have to file. The order of this court was to file within 1 month after they were served. And my lord, according to your direction, we have served long back, my lord. I can show you from your. We have served on 7. We have served on 7/11/24 after your lordship's order for serving all the plaint and documents for dispensing with the writ of summons. It was ordered that we have to serve again. So we have served again all the plaint and other documents on 7/11/24, my lord, and they have not filed their written statement. So their defense should be struck out, my lord, and this matter, my humble submission is, should be placed at undefended since they have chosen not to file any written statement before your lordship, my lord. My lord. My lord, clause 11, my lord, I am going through of the judgment which has gone through till now, where an application for revocation of leave is made at the initial stages of a suit, the allegations in the plaint must be taken to be correct, and the court will not enter into disputed questions of fact. Page 11, para 11 or clause 11, my lord. My lord, it is not their case that our suit is filed mala fide. So the question of mala fide, I am not going into, my lord. Balance of convenience, I have already submitted, my lord, that it is not, they could not say anything that it is overwhelmingly in their favor. And also my submission, it is not a voluminous matter to be tried here so that it can easily be tried in this court. In deciding the question of balance of convenience, statements of a general nature contained in affidavit affirm for purpose without particular are useless, my lord. The court must consider the facts and cannot proceed to act on a vague allegation devoid of particulars, my lord. My lord,
anything
at page 12, my lord, it has been laid down by division bench of this court in case of Ritu Sajadev Supra that once a leave under clause 12 of the latest patent has been granted, then the same should not be revoked at the instance of the defendant where the question raised is far too difficult to determine upon affidavit of evidence. My lord, the business of the plaintiff is completely run from the Kolkata. Hence, there is no business at Kolkata. But yes, they may plead that the business the defendant do not have any business. That also does not take away the jurisdiction of this court because the defendant do not run any business from Kolkata. In this regard, my lord, I will rely on another judgment of Madras High Court, my lord. Madras judgment
yes,
my lord. Just a minute. Madras High Court judgment ওকে একটা কপি দিতে হবে। I will give you. I will give you. My lord, in the High Court of Judicature of Madras, the same point was contested. My lord, will come to page 13, para 21, my lord. I am not going through the factual aspect part of the matter, my lord. My lord, section 16, 17 and 20 of Code of Civil Procedure, which deal with the jurisdiction of a civil court to entertain suits, are made inapplicable to the High Court in exercise of original jurisdiction by section 120 of the Code of Civil Procedure. Therefore, it is well open to High Court in exercise of its original jurisdiction to receive and hear suits for which even a part of cause of action has arisen within its jurisdiction, my lord. And para 22, a reading of clause 12 of latest patent extracted above would show that all that is required in order to maintain a suit on the original side is to show that a part of cause of action has arisen within the jurisdiction. Para 23, my lord. The learned counsel appearing for the plaintiff, this court cannot consider the evidence on record or decide the issue of jurisdiction while considering the application for revocation of leave. The scope of inquiry is an application for revocation of leave is very limited, inasmuch as the court has to take the allegations in the plaint as true and see whether the plaintiff has demonstrated that any part of cause of action has arisen within the original jurisdiction of this court. A roving inquiry of the evidence available, the effect of the evidence or probabilities of the case cannot be conducted while considering the application for revocation of leave. Para 24, my lord. It is a well settled principle in the Indian Mineral and Chemicals Company and others versus Deutsche Bank, reported in 2004 12 SCC 376. The Honorable Supreme Court had in fact made it clear that while considering the application for revocation of leave granted under clause 12 of latest patent, the assertion in the plaint must be assumed to be true for the purpose of determining whether the leave is liable to be revoked on the point of demurrer. After setting out the basis on which the plaintiff had claimed that the part of cause of action has arisen within the jurisdiction of High Court of Calcutta, the Honorable Supreme Court went on to hold, once from a reading of the plaint it is shown that a part of cause of action has arisen within the jurisdiction of Calcutta High Court, the division bench of Calcutta High Court was not justified in revoking the leave. Para 25, my lord, the Honorable Supreme Court had in fact reiterated the observations of Rankin CJ in Secretary versus so decided as early in 1932, reported in AIR 1932 Calcutta. The said observations are as follows. I do really protest against question of difficulty and importance being dealt with by an application to revoke the leave under clause 12, the latest patent, and take the plaint off the file. Normally, it is well settled that the proper way to plead to the jurisdiction of the court is to take the plea in the written statement as a substantive part of the defense, except in the clearest case that it should be the course. And paragraph 26, my lord, the above observations of Rankin CJ was reiterated by Honorable Supreme Court in very recent decision in Isha Distribution House Private Limited versus Aditya Birla so cited supra. The Honorable Supreme Court, after referring to the judgment in Indian Mineral so cited supra, concluded that if there is a dispute on the question of fact regarding the jurisdiction of the court, the approach of the court should be to allow the defendants to raise the question of jurisdiction in the written statement and decide the same on the evidence after such evidence is placed on record, my lord. The Honorable Supreme Court had in fact pointed out that once there is a factual dispute on the question of jurisdiction, the court dealing with the revocation application will do well to defer the decision upon evidence. In fact, the Honorable Supreme Court pointed out that except in rare cases, the question of jurisdiction, particularly territorial, which depends on the evidence, should be decided only along with the other issues and suit after the evidence is recorded. The revocation of leave in such cases is not advisable. My lord, paragraph 28, my lord. Useful reference could also be made to the judgment of division bench of this court in Raghavan versus Kalanithi Maran, reported in 2013 5 CTC 801, wherein the division bench again pointed out that the court, while deciding the issue relating to revocation of leave, cannot go into the evidence, appreciate the evidence, and render a finding on the merits of the claim. Paragraph 31, my lord. As I have already pointed out, the Honorable Supreme Court has categorically laid down the court while deciding the application for revocation cannot go into evidence and decide the question of the fact, and it has to proceed on the assumption that the allegation in the plaint are true. If we are to test the case on hand as per principle of law propounded by the Honorable Supreme Court in Indian Mineral, my lord, again they have relied, cited supra, it has to necessarily concluded that the leave granted cannot be revoked, my lord. And lastly, paragraph 33, my lord. In P.T. Kumar Koya versus Tamil Nadu Chess Association cited above, the division bench of this court has pointed out that the belated application, my lord, I am on this also, the belated application for revocation of leave cannot be entertained, and if it is shown that the defendant has acquiesced in the conduct of the suit and had participated in further proceeding of the suit, such defendant cannot seek revocation of leave. So, my lord, they have done the same. They have come much later with the revocation of leave before
What they have
submitting.
done in between?
My lord, this application was interlocutory application, the prayers, whatever was granted, that was vacated, and thereafter we have again served them this application. In the meantime, this suit did not come up, my lord. We have pursued, and after that they have come up with this revocation of the leave, which we have contested from the very beginning. In the meantime, my lord, after persuasion, the matter did not come up, and there was a gap of 2 years, my lord. After that, they have come up with the revocation of leave.
Yes.
My lord, there is a detailed discussion of the division bench, which I am not again going through, my lord, for. My lord, there are other judgments which I am also submitting. I am not JP exported copy today. My lord, they have gone through the same Supreme Court judgments, my lord. I am not repeating, I am just submitting before the court. হ্যাঁ ম্যাড্রাসটা দিচ্ছি ম্যাড্রাসের কপিটা আমার আছে আমি তোমার জন্য পড়িয়েছি দেখছি কোথায় গেল এই যে জিপি
Yes.
Hence my humble submission, my lord, the revocation of leave application should not be granted. The prayer in the revocation of leave application should not be granted, since we have sufficiently shown that the cause of action partly has arisen within your lordship jurisdiction, and also they have submitted to the jurisdiction, and thereafter, as afterthought, they have come up with the revocation of leave application.
Yes. Yes, what is the content?
Refresh your lordship's memory. Lordship, the case of my learned friend is that this agreement or the letter of intent was executed in by them in Calcutta, and therefore this court has jurisdiction. Your lordship kindly takes up my application at page 31. Your lordship had already placed it, but just for the sake of convenience, your lordship, just to refresh your lordship's memory, kindly takes up page 31.
Yes.
So page 31 is an email by the plaintiffs, Jeju Metals Dharwad, to the defendant, wherein they state, please find herewith LOI with some amendments. Please go through the same and finalize the final draft LOI so that it can be signed on Monday. 2 key personnel along with Mr. DK Singh will be reaching at your plant on Monday. My plant is in Dharwad. Now your lordship kindly turns over to page 32. This is the gate pass.
Yes, you have shown that.
Yes, your lordship. Mr. Ajay Singh, which my learned friend is trying to.
That's correct. If you so, what about the money? The part payment was
Lordship
made?
kindly takes up their plaint. This is not how they have pleaded the cause of action to have arisen within this jurisdiction of this court. Lordship kindly takes up their plaint at page 24, paragraphs 24 and 31. This is an afterthought because they cannot save the jurisdiction. They have come up and said that the bank account was within jurisdiction, but that has to be pleaded while taking leave. Lordship kindly takes up paragraph 24 of the plaint at page 10.
Yes.
The plaintiff states that the plaintiff's claim for a decree of rupees 1.57 crores and further damages for non-supply of coal until resumption of regular coal supplies in the instant suit arises out of disputes arising out of the letter of intent. So dispute arises out of the letter of intent which is signed in Dharwad. arising out of the letter of intent such and such, and as such is a commercial dispute. The plaintiff entered into the said letter of intent on 28th of December 2020 within the jurisdiction. This is how they've pleaded. Now kindly takes up paragraph 31 at page 12 of their plaint.
Yes.
How they have pleaded jurisdiction. The cause of action partly arose on or about 1st of June 2022 at the plaintiff's place of business, that is unit number such and such at Rafi Ahmed Kidbai Road within the jurisdiction aforesaid, and partly arose at defendant's place. They have not stated in their plaint that their bank account is within the jurisdiction, or that is how they are trying to invoke the jurisdiction of this honorable court. Now your lordship may kindly also see the documents that they have relied upon in the plaint to show kindly takes up page 42. All the emails that my learned friend has relied upon.
Page 32.
42 of the plaint.
Yes.
So at clause 12, your lordship will take what is there in the plaint to be proven correct. In the plaint itself, they have pleaded the cause of action on the basis of the letter of intent, which is admittedly executed in Dharwad. Now, after I make this application, they come up with an afterthought and annex the bank account details. Kindly takes up page 42, your lordship. This is the email that they are relying upon to say that Ajay Kumar Singh, Jeju Metals, has emailed it from Calcutta because they've used the MD ID to the defendant. Now, your lordship kindly sees in all these emails, CC, Jeju Kolkata, Jeju Dharwad. Lordship, Jeju Dharwad, where the work is actually going on, has been marked a copy in each and every email. Kindly takes up page 44. Page 43, the next page. Lordship, again, your lordship will find.
So this is a matter of trial.
My lordship, kindly, if your lordship,
Where
lordship
you
on the
received-
documents taking the plaint to be true and correct.
Correct.
Lordship, they themselves have annexed emails where they have been mailing the Dharwad unit. The agreement is executed in Dharwad. I have produced the gate pass, the email correspondence, and the rest of the email correspondence that they have relied upon is also shows that the correspondence was with Jeju Metals Dharwad. Now, your lordship, the other aspect that my learned friend is trying to impress upon is that I have not filed my written statement. Lordship, I have, before they have filed this suit before Calcutta, I have filed a commercial suit in Dharwad. This suit is a counterblast to the suit that I filed in Dharwad. Now, your lordship, kindly takes up. I do not know if your lordship has.
What is the suit you have filed in Dharwad?
Your lordship, my suit was for. Your lordship, I used to procure coal, give it to them for processing, which they used to process it and make it to low ash metallurgical coal. Now, your lordship, they had certain disturbances in their plant. My coal was lying in their plant. They were neither processing it nor handing it back to me. So I had filed a suit in Dharwad. Your lordship, I have a copy of the suit if your lordship wishes to.
What you want to say?
Lordship, the impression that my learned friend is trying to give your lordship that I have not filed my written statement and therefore I have come up with this application is not the true and correct fact.
No, that is neither there nor.
Very well, lordship.
So you filed the suit.
Lordship.
Automatically, you have not filed the written statement.
Lordship, I have not filed the written statement. Because I have already filed a suit.
Filing a written statement, not the ground for revocation.
No, your lordship, I thought your lordship, my learned friend was trying to prejudice your lordship by saying that I have not filed a written statement. I instead come up with clause
He is
12.
telling that only that's why you have not filed the written statement. That's why you subsequently came with an application for revocation after
No.
2 years.
Your
That is
lordship,
the
kindly.
submission.
No, your lordship,
Our
kindly
submission
takes
is
up.
that you came with this application after 2 years. The delay in terms of the several judgments, you have to come at the very early stage for revocation of that.
Lordship, kindly takes up. What is that? Your lordship will kindly. Lordship, this application was filed on 14th of March 2024. My learned friend had issued on 7th of November 2024 by a lordship's order.
For?
The plaint was served on me on 7th of November 2024 and I have filed this application in March 2024. So, Your Lordship, immediately upon
prior to that, that's
Lordship,
what she's
prior
talking
to
about.
that, Your Lordship, they had moved an injunction application.
Application.
Your Lordship, they had ex parte got an appointment of receiver. Lordship, we had filed a vacating application,
Correct.
bringing all such records, all such facts on records, and also taking the point of maintainability of this suit, and the fact that they have suppressed the fact that I filed a suit prior thereto. That was heard, and Your Lordship, this honorable court was ultimately pleased to vacate the ex parte ad interim order of injunction and discharge the receiver on the ground stated in my application. Thereafter, Your Lordship, when this suit came before Your Lordship, they had not issued the writ of summons or lodged the writ of summons. They do so in November 2024, and my application is in March 2024, Your Lordship. So, Your Lordship, my application is even before they have filed my officially served me.
When you received?
Lordship, 7th of November. That was by way Your Lordship's order.
7 November 2024.
Lordship.
My lord, this order was passed by your lordship on 7th of October 24. My
October
lord,
2024.
may I
Corrected.
আচ্ছা একটু বের করে দিন।
Yes, it is there. So the
My lord, it was on the second page, my lord, we'll find that we have asked for dispensation of the writ of
lodging
summons,
of writ of summons.
and your lordship has directed to serve the copy of the plaint along with all documents to the counsel for the defendant within a week after the
Yes, Yvonne.
So, Your Lordship, even before.
there was a liberty to file written statement which they have not opted for.
Lordship, even before the plaint was served upon me, I have filed this application on the basis of the plaint
lord,
annexed to the injunction application.
My lord, copy of the plaint and petition, everything was served upon them before that, my lord.
I do admit that. From the injunction application, I get to a copy of the plaint. On that basis, as soon as the vacating application was allowed and their interim application was rejected, Your Lordship, I come up with an application in March 2024 for vacating for revocation of leave under clause 12. They serve the plaint later on in October 2024. They do not bother to carry out the lodge or the writ of summons. So there's no delay on my part. In fact, the plaintiff in the suit itself has delayed the lodging of the writ of summons, knowing fully well that this suit cannot stand before Your Lordship's court in this jurisdiction. Lordship, those are my submissions. Therefore, Your Lordship, this court does not have jurisdiction to entertain the instance suit. Your Lordship, the Justice Tandon's judgment I have also relied upon. It's the same judgment, Your Lordship. The principles are now crystallized.
You will file written notes.
Lordship, I'll file a written notes.
Hearing concluded.
May I also be allowed to file?
Press for time to file written notes of argument. Let the written notes of argument file within a week. This is the matter on 13th August for filing written notes of argument under the heading to be mentioned.
Grateful, Lordship.
Same liberty is given to me, my lord.
Both parties. Yes.
I appear on behalf of the plaintiff in this matter. Your Lordship, Mr. Abhrujit Mitra was arguing for disclosure of additional documents. Lordship, he's suffering, he's undergoing, he's a bit under the weather. He's not come to court today. So, Lordship, I was humbly praying for an accommodation. So because it's on his personal grounds, because of him being unwell, Your Lordship, we are unable to do the matter today.
Persons no, yeah, fixed matters.
Lordship, I understand, Your Lordship, Mr. Mitra was ready in the matter, but Lordship, he just got unwell, because of which he could not come today. He was there in this week, Your Lordship, but he's unwell. He couldn't come to court today.
Yes.
My lord, if personal ground is there, I cannot say anything.
As per the prayer made by the counsel for the plaintiff, case is adjourned. Let the matter appear clear date 10 September at 11-12 month रखो बोले से 11:30 होगा.
My lord, if instead of
12 p.m.
My lord, instead of 10th, maybe some other dates, my lord.
23rd September at 2 p.m.
Very well.
20, yes.
Yes.
23rd at 2 p.m.
Very well, Lordship. I
September.
apologize, Your Lordship.
Okay, next.
In this matter, Mr. Aniruddha Mitra was appearing, he was arguing in respect of why this suit should be the commercial suit. Don't you will remember, on the last occasion, Mr. Mitra was addressing your lordship as regards the defendant had taken a point that this was not a commercial suit. He was arguing, he was on his legs. His lordship, I'm only praying for a short passover.
You are appearing for?
The plaintiff. And he will just refer to certain judgments on a short passover.
Passover.
Great.
Yes.
Well, this is that matter where your lordship had passed a decree, and an order 9 rule 13 has been made. The other side, where points have been taken. I'm in reply, I as a matter of just about to start my reply, Well, basically 3 points have been taken that I was aware of the address, which is the address. May I just remind your lordship, the suit was filed, with a Calcutta address carrying on business. They had the registered office in Durgapur. Now, when we find the writ of summons, obviously because I will point out why, the Calcutta office address was given. Now, when the Calcutta office address is given, writ of summons is returned. We take out an application before your lordship, for substitute service, where we mention about the Durgapur office address also. But your lordship exercise your lordship's discretion, saying that no substitute service, advertise. We advertise. They do not come, then a decree is passed. After that, they come out and take out an application to order 9 rule 30. In that application, they take points as in we were aware of the Durgapur address, one. Second, what they are saying that in their application, they said there was no newspaper publication. Once I brought in my opposition, they said these newspapers are not circulated in Durgapur. And Mr. Bhattacharya has cited one judgment relying on section 21 of the Companies Act. So I'll try and reply to all these three. First things first, your lordship will kindly have a look at the plaint. I know I'm not supposed to go through the facts anymore, but I'll just show two things, which I thought my learned friend should have pointed out before he made that submission, But will kindly, rather, your lordship will kindly take, their application, their application, Malat, where Malat they have annexed the plaint, Malat, so it will be in the same document, so the same once then your lordship, it will be easier, Malat. Malat, page 37, if your lordship kindly sees, Malat, is the agreement. Malat will kindly see page 38. 37, Malat.
Yes.
Malat, it's found that, Malat.
GA com 5.
Malat, this will be GA 2. GA 2, Malat.
Yeah, GA 2 though.
24. 24. Huh. Wait. I think your lordship has got the. Thanks.
Yes.
Now, Malat, page 37, if your lordship kindly comes.
Yes.
Malat finds Balaji hydrocarbons, Malat, that is their address. One will find that it is the Calcutta address.
Yes.
Now, Malat, your lordship, it is very well known, Malat, it's a fundamental principle that if there is a change of address, then it is the duty of the person concerned to communicate.
Yes.
And other than that being the fundamentals, Malat, your lordship will kindly take page 46. If your lordship takes page 46, Malat, your lordship find 9, Malat, clause 9, talks about notices. Where, Malat, both the parties have agreed what would be the address of the notices.
Yes.
Your lordship will find lessor, it's Kendeline Lane.
Yes.
That's the Calcutta office. Now, Malat, may I just read that clause once? All notices required or permitted hereunder shall be in writing and in the English language shall be sent by registered post with AD or by facsimile transmission with confirming facsimile receipt or electronic mail to the registered ID addressed to the address of each party set forth below, or to such other address as such other party shall have communicated to the other party in writing. So, if there is a change, they will have to inform me. Notice shall have been served when received and in all cases of such and such ballot in accordance, provided that the confirming copy is sent to the other party in accordance with the non-facsimile notice. So, Malad, this is an agreement between the parties. This will be the notice, or this will be the address for the notice. So, Malad, today what my learned friend is arguing is that I should have acted in breach of the agreement, Malad. One is that. Second, Malad kindly appreciates, Malad, if he has changed his address, Malat, then regularly, Malat, the post office has a redirection done. That is also nowhere there. So, Malat, I acted in terms of this agreement, which they have also annexed. So, I have acted in terms of the agreement. Your lordship had also seen this. I remember, Malat, your lordship had seen this. And that is why, Malat, in spite, Malat, your lordship will kindly have a look at my application. Malat kindly takes the affidavit in opposition, Malat. Where, Malat, we have Malat annexed, rather, Malat sought for an order. Kindly see 17, page 17, Malat.
Yes.
Malat, there your lordship will find the first prayer was for Durgapur. Your lordship considered the agreement.
Yes.
And thereafter, Malat, your lordship, it starts at 13. I'm showing the prayer, Malat. Therefore, your lordship had directed that 2 newspapers, local.
Yes.
So, Malat, I humbly submit, Malat, on the facts of this case, where there is an agreement already between the parties, not acted upon, I have sent you the right address. Thereafter, Malat, I have done substituted also, Malat, service.
So, what has happened to the first report? What is the first report?
Malat, the first report was May I just give you a moment, my lord. Undelivered packet marked left for the defendant. My lord, that have my lord, that is at annexure A, my lord, which is page 18, my lord.
Of your AO?
18,
Of your application?
20. Yes, my AO, my lord. AO, my lord.
Page 20. Undelivered packet left could not be served as a defendant because the door of the defendant office was closed and the defendant was.
And then, my lord, next one is also there. By registered post, it went through the GPO, my lord.
Yes.
Left for the defendant.
Yes.
And my lord, no alternative address given. That's why we send it through the GPO, my lord.
So that's why the bailiff as well as the GPO both have been taken care of it.
And that's why I came up before your lordship, my lord.
After the publication.
Yes. Now the publication, my lord. My lord, kindly sees first in their application, they have said that there is no newspaper publication. That is paragraph 18. Then your lordship will kindly see, my lord. Sorry, my lord. Paragraph 18, he says there is no newspaper publication. Now, my lord, we come up with the newspaper publications. Paragraph, my lord, that your lordship will kindly see at page 23 of my opposition.
Yes.
And your lordship will also take their reply in conjunction with this, my lord.
What is the Bangla newspaper?
But Bangla is Ei Shomoy.
Ei Shomoy. And
English is Times.
Times.
Which, my lord, they are now saying it's Times City. There is no newspaper known as Times City, my lord. On the right hand side, your lordship will find Times of India. And, my lord, very interesting, my lord. And I'm grateful. Newspaper. My lord will kindly see. My lord, Annex C, is your lordship there, my lord?
Yes.
Page 23, my lord. Your lordship will find Times Interact on the bottom, my lord. My lord, this is, my lord, the advertisements they do. The Times, my lord, advertisements to the Times newspaper. Your lordship, very important, my lord, kindly sees the branches which is given at the right hand. The box, my lord, at the bottom. District, my lord, your lordship will find.
Asansol.
If it's not visible, my lord, I've got the newspaper.
Yes, Asansol traffic.
Asansol traffic jam in Durgapur city center.
City center.
So, my lord, they are taking, my lord, advertisements in Durgapur city center.
Yes, Durgapur.
In Durgapur, he's also in Durgapur. And to say that no, it has not been served, my lord, that is not nice. It is not correct. My lord, I also wanted to bring this, my lord. My lord, but this is the Times of India, and inside it's Times City. So, my lord, it's part of the A, and Times City, my lord, ends here. And it's the advertisements which they give. My lord, your lordship knows every newspaper has a dedicated page for advertisements. So, my lord, I say, my lord, from the newspaper and its advertiser. The advertiser says he has got it in Durgapur. But what else can I show?
Okay.
So, this is my submission. Now, my lord, with regard to section 21, my lord, he has relied upon. Judgment. My lord, he has relied upon, my lord, a
1991 SEC online.
Yes, my lord. I'm grateful. My lord, he has relied on this, my lord.
Service upon company.
Yes, my lord. My lord, may I humbly submit, my lord, section 21 is an enabling provision. It's an enabling provision. It does not talk about service of writ of summons. And therefore, my lord, it is not restricted. It is a wider, my lord, section which allows everything, including a writ of summons at any address under the CPC. My lord, this judgment, my lord, has been considered and interpreted, my lord, though by a single judge, but interpreted, my lord. Kindly takes, my lord. That kindly comes to paragraph 6. Sorry, page 6, madam, sorry. Just in the middle, just 1 or 2 lines below the middle portion of that.
Supreme form, yes.
The reliance placed on the decision, has your lordship?
Yes, yes.
Hornanath Ghoshal is misplaced. In fact, it has been held that the modes of service mentioned in section 148 are not the only modes of service of a document on the company. And it 61 Supreme Court it relies on 1961 Supreme Court, and there is one Rangoon judgment. I also find that service of the corporate of the company is valid and good service when the summons allowing the plaintiff is duly received at such office. Order 29 Rule 2 does not limit the service of the summons to the registered office of the company alone. There is also nothing in section 20 of the Companies Act 27 which limits the mode of service. The provision, as the words indicate, is only an enabling provision as to the manner and mode whereby service is effected in a company or corporation. And there is a reliance on a Delhi report, in any event, this is thereafter, it was a case of extension of time for serving written statement. So that wouldn't be of any further help here, But this is, I'm just referring to that 1961 SCC Online Supreme Court 277.
Yes.
And where again, section 148 has been dealt with. Kindly takes internal page 15, It will be on the top.
Yes.
Just below, just above the quotation. The first is a provision in section 148 of the Indian Companies Act 1930. It says akin to section 20.
Where from you have been?
First
question of arises.
The first is a proviso, But you'll also will find quotations here, the document, just above that.
Okay.
What has found that,
Where from?
Page 15. Page 15. Then the first. May I hand
Yes,
over?
yes, got it.
The first is a proviso in section 148 of the Indian Companies Act 13, which was then in force. That section provides a document is served in a company by leaving it at or sending it by post to a registered office of the company. So it's the same thing, The other provision is Order 29, Rule 2 of the Code of Civil Procedure. We may, however, read the opening words of this rule for this purpose. They are as follows: subject to any statutory provision regulating service of process where the suit is against a corporation. It will be seen that Rule 2 of Order 29 of CPC is subject to any statutory provision regulating service of process, and where there is any specific statutory provision, Rule 2 would not be applicable. The only other statutory provision is in section 148. But that provision, the words themselves show, is merely an enabling provision. And it nowhere lays down that the method mentioned in section 140 is the only method of serving all documents in a company. And that has been very recently considered, by Justice Kapoor, and that is why I just relied on that, So, what fell from my learned friend, may not be correct in the interpretation of section 21. I have the Rangoon also, if your lordship, it's a very short judgment. I can give it to your lordship, This is AIR 1941 Rangoon 339. Paragraph 3. These talks about the Burma Companies Act, but more or less the same provision, So paragraph 3 also says the same thing. These are my submissions, only one submission in the nature of a disclaimer, In the event your lordship, is of the view that it should be recalled, because I do not know, it is obviously a lordship's judgment, then in that event, will kindly consider the wording of Order 9, Rule 13 with regard to conditions. I have shown your lordship, the documentations and that they were acting in breach. of that clause 9, where they were under an obligation to inform us. Considering these, will kindly consider that at least if a lordship is recalling, then they should be put to terms for putting in the entire decretal amount.
Okay.
না সেটা তো ওখানে এতে আছে contractual আছে
Yes.
I have got a judgment showing that it is also a law that you should inform in authorities, income tax and everything, but I don't need to show because the contract only says so. So they cannot say something contrary to the contract. Well, those are my submissions. I'm grateful.
Lordship will kindly give us a date for reply, Lordship.
But I showed new judgments for it. I was not aware that he was going to take the point of section 21. So,
Counsel for the defendant concluded, counsel for the plaintiff concluded his arguments in connection with GA5. GA2 of 2025, 2024, 2022. Counsel for the defendant prays for time to give reply. According case is adjourned. Let the matter appear on 13th August.
Whenever. Grateful. Very good.
Lordship, 25, my lord, I am for the petitioner.
Yeah.
On the last occasion, Mr. Quad has already concluded his part of submission. Mr. Quad has already completed his part of submission. If my learned friend wants to.
My lord, on the last occasion, as far as I remember, 2 judgments were left to be cited by my learned senior friend.
Lordship, he is in court number 17.
So until unless he concludes, my lord, it's very difficult for me.
Kindly
Otherwise, it will be in a piecemeal manner, my lord.
Manutosh, orders. ये नहीं कौन वाला केस का
মোটটা আছে কি বলবেন
हाँ ये केस कौन सा है तो फिर उसमें ये क्यों लगाया गलत डाला वो तो फिर आए फिर काटा तो फिर हम लोग उसमें मार क्या करता था आप दूसरा फाइल दिया था हाँ फिर ये ऑर्डर क्यों आया ये G5 क्यों है वही केस का दूसरा केस का हाँ You are appearing for whom?
Respondent.
Yes. You have to complete your argument.
Yes.
Lordship, we have already completed only 2 judgments are to be cited.
That is left to issue.
So
Currently,
you
he
will
is
not
in court
you will
number
not cite the
17.
judgment. You will not cite the judgment.
Lordship, I am not aware of the judgment.
So I am closing your argument.
Lordship, he is in court number 17.
So appearing for a short adjournment. Not today.
Grateful.
My lord, again, then no date was fixed, my lord.
Call.
My lord, we would be prejudiced. My lord, this is a Chapter 13 application. This is pending since long, my lord.
Then I will hear you. He will go to the appeal. On no opportunity be given. Then you will come here.
No, my lord, that is not what I. Very well.
Grateful.
Lord, I appear for the petitioner in this matter, my lord.
Yes.
The defendant class.
Yes.
Well, this is that framework under the Reserve Bank of India.
Yes.
Yes, my lord, I was on the last occasion, my lord, I was drawing your lordship's attention to a supplementary affidavit that was filed by the bank. And this has been affirmed on the 10th of April 2025.
Yes. Which page you are relying on?
Yes, my lord, I was, my lord, kindly takes, my lord, from page 31 onwards. This is only to show, my lord, that, my lord, since 2022, the bank was aware that I am a registered MSME unit.
Yes.
Yes. But page 31, but this is a request from the bank that I kindly see the email. This is 4th of February 2022.
Correct.
The bank writes that they had that I opted for an offer that is GECL offer. So if I have to opt for the offer, my lord, I have to fill up a form. Now, my lord, they, my lord, provide me with the form on the same date, my lord, on 4th of February 2022, which is their letter. In fact, this letter came along as an attachment to the email at page 31. Now, my lord, I respond on 7th of February 2022, page 36.
Yes.
This is my email. Doors due to State Bank of India SME Park Street branch. Kindly takes page 37. This is the annexure A that I was required to fill in as per their format. Kindly takes paragraph 2 of this letter. In this connection, we would like to avail a loan of, this will be 1 crore, and we confirm and certify as under A, we are functioning business enterprise / MSME with Udyog Aadhaar number such and such. So this is on, my lord, 7th of February 2022. And, my lord, the credit facility is commenced from 12th of February 2020, re-enhanced, my lord, on in the year 2022 itself. Because, my lord, in their affidavit in opposition, my lord, they have given the series of letters of arrangement that was issued by the bank to me. Even in 2022, my lord, the bank is aware that I am a registered MSME unit. The framework is dated 17th of March 2016. The demand notice by the bank is, my lord, 6th of December 2023, wherefrom I came to learn that my account was declared as a non-performing asset on 29th of November 2023. So my humble submission, they could not have declared my account as an NPA, because under the framework, my lord, they had to follow certain steps which has not been done. But this was my argument as far as the ad interim stage was concerned. Now, my lord, kindly takes, my lord, their affidavit in opposition to the supplementary affidavit that has been filed by them. This affidavit was affirmed, my lord, on 21st March 2025.
Yes.
No, I'm sorry, my lord. Affidavit in opposition was filed. Affidavit के बाहर करो. Yes, but they do not dispute or deny my statement that the bank was already aware that I am a MSME unit from 7th of February 2022. But kindly see my averment in my supplementary affidavit and their response. My relevant averment is, my lord, yes, page 5, paragraph 9 of my supplementary affidavit. The petitioners, pursuant to the directions contained in the email and the letter dated such and such, had duly filled up draft Annexure A. Annexure A was sent to the respondent bank under cover of an email dated such and such. It would thus be evident from the statements made in the foregoing paragraphs of the supplementary affidavit and the documents disclosed therein that the respondent bank, even before classification of the account of the petition number 1 as NPA, was aware that the petition number 1 was a registered MSME unit under the MSME Act 2006. Now, my lord, kindly see, my lord, paragraph 5. Yes, paragraph 5 and 6 specially, page 4 of my supplementary affidavit. I have again, my lord, reiterated where which they have dealt with in
Affidavit.
yes, my lord, this supplementary affidavit where yes, my lord, page 4, paragraph 6.
Yes.
Yes. I say that the respondent was and continues to be fully aware that the petitioner number 1 is a MSME unit registered under the provisions of the MSME Act. I say that the said fact as well as that the said fact was well within the knowledge of the respondent even prior to the classification of the account of the petition number 1 as NPA. The respondent bank was aware that the petitioner was a unit under the MSME Act 2006. Now, this is my categoric statement on the basis of the documents which I have disclosed. Now, Lordship will kindly take their affidavit in opposition. The affidavit, I'm sorry, my lord, it was affirmed, my lord, on 24th April 2025. Affirmed by one Shubroto Shaha.
Yes.
Yes. Kindly see, my lord, page 5 of their affidavit in opposition. They do not dispute. Kindly see the last 4 lines of page 5, which is a part of paragraph 5. The entire subparagraphs of paragraph 5 of the affidavit in opposition filed by the respondent defendant are required to be read conjointly to arrive at the proper meaning and purport of the statements made in the affidavit in opposition. Now, next page, Lordship sees paragraph 6. As regards the averments made in para 6 of the supplementary affidavit, I do not admit anything thereof that is contrary to or inconsistent with the undisputed records. However, I say that as can be understood from the very stage of the proceedings at which the purported emails have been brought on record of this honorable court, that the purported exchange of emails which are part of several email exchanges between the petitioner, plaintiff and the defendant respondent bank was lost sight of by the petitioners all along, and it is only in order to shake the valid stand of the respondent bank in its affidavit in opposition, the petitioners are trying to introduce this document to mislead this court. However, it is once again asserted that it is acquiescence on the part of the petitioners all along, inasmuch as they have never raised this issue at the appropriate stage of the proceeding after default and prior to the classification of the account as NPA. But they do not dispute. My lord, they say categorically, I do not admit anything which is contrary or inconsistent to the undisputed record. And they say that I did not raise this issue before at all. My lord, my plaint case and my petition case proceeds on the basis that they have not followed the circulars of 17th of March 2016. I understand, my lord, that in the petition I have not disclosed the email, but now, my lord, I have filed a supplementary affidavit showing that even before declaration of my account as NPA, NPA was on 29 November 2023. 1 year or 1.5 years before that, the bank was fully aware.
Okay.
Now, my lord, in their affidavit in opposition, they have disclosed various documents in volumes where they have tried to show that they have declared my account as SMA2. Kindly see affidavit in opposition to GA1 volume 2 page 157.
Yes.
Yes, kindly see, this is a letter that they issue to their assistant general manager on 17th of October 2023. Kindly turns the page, my lord. This is their bank records, page 158. Page 158. My lord, kindly see, but there are inconsistencies galore. Kindly see, my lord, but from in the middle of the page, my lord, SMA1/SMA2/NPA. But kindly see, LNPA date 30th of November 2023.
Yes.
Whereas in their demand notice of 6th of December, they say it's 29th of November 2023. Now, kindly, my lord, comes towards the bottom of this page. My lord, there is a row which says first stage examination done on with result. But kindly see towards the right hand side, the account is classified as SMA1 as on 30th of September 2023. Now, my lord, as per the framework, As per the framework of the 17th of March 2016, SMA1 is declared when the principal and the interest is overdue between 31 to 60 days. So they are aware of the circular. Now, Lordship, kindly comes to the next document, which is at page 162. This is another letter sent by the regional manager to the chief manager. But kindly see, this is an irregularity report for the month of 31st of August 2023, page 163.
Yes.
But kindly see, my lord, towards the top, irregularity report for the month of 31/8/2023. Name of the borrower is mentioned. Status of the borrower, willful, non-cooperative, CIC, CRILIC, standard. Now, date of default, irregularity in the account, 31st August 2023. And beneath that, they say SMA category is 0.
Where is?
Lordship has seen the date of default.
Yes.
Lordship will kindly skip the next row and thereafter SMA category, SMA 0.
Category, yes. Yes.
Yes. This is just to show, my lord, though they have tried to show that there was irregularity in my account, if there is irregularity of the account of a registered MSME unit, the banks are required to follow the circular of 17th of March 2016.
Why it is not settling in the local adalat, the mediation?
Lordship, their contentions are not appropriate, and I will also demonstrate that with the documents relied on and the recent judgment of the Honorable Supreme Court, wherein this exactly on this issue, that whether it is only the responsibility of the bank or whether the borrower has a responsibility, that has been reconciled on 25th of July, Lordship. That this has this of the on the Pronets judgment, there has been a subsequent judgment which has reconciled this fact, and I'll demonstrate that this account, the unit was closed. It's a closed unit, and they have only on the strength of this judgment of Pronets, they have belatedly approached this honorable court because of that.
Okay. Yes.
Very well. Now, my lord, kindly see, my lord, page 177. In their affidavit in opposition, my lord, they have not made a single averment as to, or my lord, the clarification, or my lord, the explanation as to why they have not complied with the framework. But they have disclosed the irregularity reports for various months. They have shown that it is SMA1, SMA2. Even at page 177, which is the status report of 30th of September 2023, they again say that the date of default is 31st August, SMA category is SMA1. But none of these documents, your lordship will see that there is no explanation or no statement that, my lord, as to why this document, which has mandatory force of law, is not required to be followed. Okay. There is nothing. And lordship, my lord, kindly see. I would ask you. Yes, because, my lord, at the ad interim stage, my lord, I had relied on Pronets to show that it is not the responsibility of the borrower to bring it to the bank's notice that you are required to follow the circular. The banks should on their own, my lord, follow, because, my lord, the circular, my lord, I do understand, my lord, it will bind me. But most importantly, it is the circular of the RBI, where State Bank of India must follow the circular. If State Bank of India does not follow the circular, my lord, then the acts declaring my account as NPA, my lord, is illegal. It's contrary to law. Because the lordship sees, my lord, the judgment of Pronets that I had handed over, my lord, this is yes. This is the SCC online printout, my lord. 2024 SCC online Supreme Court 1864. But only if lordship sees, my lord. Yes. Paragraph 13.
Yes, you pointed out.
I had shown it. Only one paragraph which is very important, my lord, para 18.
Yes.
In that view of the matter, we are of the opinion that the findings recorded by the High Court in the impugned order, that the banks are not obliged to adopt the restructuring process on its own as revised from time to time, could not be said to be mandatory in nature and are highly erroneous and cannot be countenanced. The argument was, or the finding was, that the bank is not required to follow on its own. Supreme Court has negated the argument.
Correct.
That is what my learned friend's argument is, that I should have approached them. I should have indicated them that I am a registered MSME unit, you follow the circular and restructure my account. I have not indicated them as on 7th of February 2022 that I am an MSME unit. The law says that it is mandatory, it has a binding force, and it is the bank who is duty bound to give effect to the circular on it. Yes, Manoj. I'll just distinguish the judgment once my learned friend finishes. ঠিক আছে, এটা তো ওইটাই।
There are two fold of arguments which I should make. One, on what has been the conduct of the bank before classification of the account as NPA. So, before placing the relevant documents, Lordship, I will once place the MSME scheme, because it is the case of the plaintiff that as per the MSME scheme, they were entitled to certain restructuring. There are certain opportunities they were entitled to. Lordship we had on the last occasions placed the MSME guidelines of 24th July 2017. Hey, তোমার কাছে তো আছে MSME guidelines. That is what you rely on.
I was relying on 17th of March.
17th of March.
March 2016.
I can refer from that also. Okay, Lordship, I will take the 17th March one, because that is only the modified version, nothing much on that. Lordship, I'm not getting into the details, but only to indicate that as per the guidelines, what is indicated in the guidelines is that there should be corrective action plans taken by the committees. Why that has to be taken? That has to be taken either for the purpose of rectification, restructuring, and third is recovery. That is clause 5 of the circular of 17th March 2016. Now, this is the purpose that options of rectification, restructuring has to be exhausted before moving into recovery. That is the purpose. And there are timelines and additional finance restructuring eligibilities. I'm not on that. Now, if your Lordship kindly takes up page 151 of the affidavit in opposition. No, Lordship, may I first place 159? Volume 2.
Yes.
Before that, may I indicate, Lordship, the plaintiff, there was a first sanction of rupees 8.05 crore on 12/2/2020. Thereafter, there was an enhancement on 7/2/2022 to 9.5 crore. Thereafter, there was once again an enhancement on their prayer of 12.02 crore, which was sanctioned on 19/8/2022. So there was twice restructuring by giving them additional finance facilities. Now, Lordship will kindly take up page 159. This is, I will show from all the documents that there were several irregularity reports which were being filed. And before that, what was the opportunities being given to the borrower? At page 159, Lordship, there is a brief gist of meeting. Meeting was conducted with Mr. Abhijit Kanjilal, one of the promoter directors at our AO Kolkata, in presence of senior functionaries, this and this, appraised the reason behind the ongoing stress in the account. It was advised to Mr. Kanjilal that the total irregularity amount as on date has to be regularized by the promoters at the earliest. Any scope for bank finance rehabilitation may be explored only after the irregularity amount is paid by the promoters from their own funds. So, Lordship knows that there are two components, one the loan component and there is the irregularity amount. There is several irregularity amounts, non-servicing of interest. Subsequently, it is classified as NPA. Mr. Kanjilal apprised the matter will be decided between himself and other promoter director, Mr. Jahan Ali Bishwash, for arranging irregularity amount, despite confiscated liquidity arising out of the fact that the factory operations has since been completely closed. So he is given an opportunity to pay the irregularity amount. Bank says that if the irregularity amount is serviced, we will consider giving more funds to you, but you please pay this. He says and that the unit is completely closed. Thereafter, Lordship kindly takes up. Again, this is one of the corrective action plans, which is the correspondence. The report has been regularly prepared. That can be seen from page 157. Then again 170. This is a subsequent corrective action plan which is being taken. Proposed immediate action plan and comments on corrective action plan for ensuring long-term viability. Here again, discussions are ongoing between the bank and the borrowers. Lordship, I will not indicate everything. I will directly go to 10A. 10A. Lordship, I'm not placing the government that this is as per this KG and all that. The reasons for the unit non-functioning is recorded. Due to this above reasons, unit is suffering from liquidity crunch, because of which the unit could not serve the interest and installment of August 23. However, there was no irregularity in the account before August 23. Steps taken by branch. Irregularity notice has been served to the customer by post and email dated this. Meeting has been held with the borrower director, Mr. Abhijit Kanjilal, on 5/9/23 for regularization of the position and future course of action. Inspection is proposed to be conducted at the branch at the factory village at this and this. Renewal of the limit has expired on 9/9/23. Continuation of the limit has been obtained from ZCC Kolkata on 8/9/23, which is valid up to 8/12/23. Inspection is going to be conducted on this and this, to indicate that even after the limit was expired, bank extended the limit even after knowing that it was an irregular account. So bank was looking into because all these were done under the corrective action plan by the bank.
Okay.
Because that I will demonstrate is also in my letter of arrangement, that I have to conduct the stage of SMA 0, 1, 2 and then thereafter go to the NPA stage. So I was all along doing this. Thereafter, Lordship will kindly take up page 175. Lordship, this is a communication of the bank itself. Bank is recording the data with respect to all accounts. Here the bank records that with respect of dual suit, the critical account unit is closed. But these are the observations received from the higher authority of the bank to
where from your reading?
Lordship 175. This last column, observations.
Yes.
These are the directions which have been given to the concerned officer of the bank
Yes.
What is to be done? The unit status is unit closed. Critical account, it is in critical. Ensure documents are live, current and enforceable. Arrange for a meeting with the borrower and try and resolve any issues for revival of the unit. Their moot contention today remains that what attempts the bank had taken for revival of the unit. Account to be regularized and renewal to be expedited. So even from the bank's end, the bank is wanting to take steps, yes, to regularize the account and what the bank has been doing. Lordship, thereafter, that the previous one, Lordship, I have shown a report. Now, Lordship will kindly see the report for the month of September 2023 at page 177. This is the report for the month of Lordship. I will directly go to this starts. The report starts at 177. I will take your Lordship to 193. Lordship, sorry, I will take your Lordship to page 184 first. Again 10A, again on corrective action plan. Lordship, this is on the stages. As the loan account is going from August, there is being non-servicing of interest that is going for default. That was in August I had indicated. This is in September. Again, similar kind of corrective action plans have been recorded by the bank, that there were meetings. Lordship, on every occasion, there has been a meeting with the concerned borrower, and there has been requests for servicing of the irregularity amount.
Yes.
Lordship, this again 10A. I'm not placing it in details. These are the measures which are being taken by the bank.
Yes.
Lordship has marked that previously also we are holding directors for requesting them for regularizing.
Yes.
Now also subsequent meetings have been held. Meeting has been held with Director Mr. Kandilal again on 5/9/23 for regularization of the position. Subsequent meeting was held with the director at AO branch controller and senior functionaries on 3/10/23. Directors were advised in both meetings to regularize the accounts immediately. Renewal of the limit was valid onto this and this. It has been extended. Lordship, thereafter is the list of the observations on the previous report, what compliances have been made. This is just to indicate your Lordship that at every stage, the bank was trying to regularize this loan account. Now, Lordship will kindly come to page 193. This is the proposal. Lordship will excuse me. Yes, Lordship will kindly take up page 193. This is on our repeated prayers. They give a loan reconstruction proposal. This is the loan reconstruction proposal. In this loan reconstruction proposal, which is given to us in 2023, there is no reference at all to the unit being MSME. Even in this loan reconstruction proposal,
When it was filed?
Lordship,
When it was given to you?
in 2023, Lordship. I will. Lordship, it was with an email, Lordship. I will just indicate that. I have not placed a lot of the irregularity reports, Lordship. These are all annexed. I'm not placing this. This is in 2023, Lordship. I'll indicate the date. Lordship will kindly, because this is in 23, will be evident from the fact that, Lordship, this records in October 31st, this and this happened. So this was thereafter, subsequent to that, Lordship. I'm placing this. The company has term loan overdue, admitted position. This is this letter, Lordship. May I place this letter? Page 195 onwards.
Yes.
The company has a term loan principal overdue of 85,21,555 on 31st October 2023, admitted position. And it next 4 term loan installments due amount comes to rupees 85 lakh. These two amounts totaling to 1 crore 17 crore
70 lakh
70 21,555. The company proposes to restructure this amount in 20 quarterly installments of this and this, starting from December 2024 as detailed in term loan schedule. There is a schedule in the proposal given. They have given a proposal. Again, the company has a term loan overdue interest of this and this amount. Again, there is a proposal with respect to the term loan. Company has overdue interest of 15,10,739 in the cash credit account. So with respect of all the accounts, this is the status where they say that we are praying for restructuring to the tune of this and this.
Yes.
Now, the company, next page, company proposes the GCL accommodation of rupees 1 crore. Company also proposes a working capital enhancement by 1 crore 20 lakh to augment its production and sales capacity. Promoters of the company will bring in an amount of 30 lakh as their additional contribution. Details revised project financials are given. Now, even in this letter, which is evidently subsequent and after 2023 or in the year 2023, there is nothing, not a whisper of there being an MSME or entitled to any benefit under any guideline. Now, and there are admission of the overdues. It is admitted position that what is overdue. Then Lordship will kindly take page 210. Lordship, this is the recommendation of the proposal. Lordship knows that a note has to be written to the senior managers by the bank, that the bank is writing on the basis of their proposal that the accounts of the borrower showed sign of stress and became irregular as interest in installments due on 31/8/2023 were not immediately paid. Lordship is not placing on that. What has been done by the bank? Bank has indicated in the previous paragraphs. Thereafter, yes, this is the date. Lordship, 24/11/2023. The borrower submitted a restructuring proposal requesting deferral of the term loan installments along with moratorium, curving out the CC irregularity into WCTL and creating FITLs for the overdue and future interest up to April 24. In the restructuring proposal, borrower has requested for additional working capital funding of rupees 1.20 crore and has proposed to bring its own fund of 30 lakhs. On 25/11/23, a surprise inspection was conducted by the branch head and CSO at the factory premises. It was observed that the factory is operating at a low key and meager capacity, utilizing about 5 to 6%. In the month of November, my Lordship, I can't read. There is a in my copy there is a seal. There is 11 days. Total production was 4.7 tons. An average approximately this and this, whereas maximum capacity stands at 8 tons. Since the capacity and production is some of the machineries were not in use on the date of inspection. Slow moving SIP since factory was briefly closed in the recent past was observed, although fresh this and this were also observed in smaller amounts catering to fresh production and orders. Discussions were held at length and factory with newly appointed official Mr. Sanjay Tiwari. I'm not on this. The level of activity, it is evident to pull the factory. Lordship, I'm not placing everything. Lordship, the fact remains that there was no involvement of the promoters because of which the factory had slipped. Yes, the operation had closed in the factory. The loan account had slipped into NPA. Thereafter, there was continuous follow-up from the bank's end for restructuring and revival. There have been 2 restructurings before that. I have indicated to your Lordship on the relevant dates. Even after restructuring and infusing huge amounts of funds into the company was failing in its function. So, in the proposal, and there was no involvement of the directors, which I will also indicate that they could not bring in the fund. I know Lordship has a fixed matter. But yes. So they could not bring in or infuse those funds, but they were wanting some additional funds from the bank. So that is public money. Lordship knows that before infusing the public money, there has to be an accountability as to why that needs to be further infused, where even after giving so much of advances, the unit could not
So the
sustain
conduct of
itself.
the conduct of the
Yes,
borrower has to be
yes.
seen.
Next, Lordship will kindly take up page 212. Now, Lordship, I'm not relying on this. I will rely on the statements if at all required, but this is the statements from which it can be shown that there was default. That this is for abundant caution. I have annexed all this, but I will rely on. Next, Lordship will kindly come to 270 first. It is in volume 3.
Yes.
Lordship, this is again in the SMS2 stage. Again, there is a corrective action plan which is being
Yes.
It's 270.
270, volume 3. All I want to indicate is that, Lordship, at SMA 0, SMA 1 and
Now
SMA
SMA
2, all the 3 stages bank has carried out the corrective action plan and rendered the findings. The corrective action plan, which is the essence or what they claim to have been refused to them,
Yes.
was done by the bank, because that is also to be done as per the letter of arrangement. Bank has done that. Lordship, 277.
Yes.
Lordship, this is 277. Again, this has the proposed, Lordship, 10.A is the proposal for the corrective action plan. There was the 13-2 letter was in the meantime served. Legal notice was served after the bank had classified the account as NPA. The bank has served the 13-2 notice and the legal notice. NPA marking was done. Physical verification of the securities was done. Again, a surprise inspection was conducted, which is referred to, Lordship, in that letter, by the SO and the branch head at the factory premises. And RM SME visited factory on this and this. Factory to be found operating, but at a very low key, at a meager capacity of 5-6%. Draft PIM has been shared with SAMBI2 and joint inspection has been conducted. Revaluation of collaterals have been done. So, Lordship, that has also been again at the SME 1, 2, SME 0 and 1 and 2 stage. It has been done. Now, Lordship, may I refer to page 282. Lordship, this is the notice they say from which they drew knowledge that their account has been classified as an NPA. Yes. I'm not placing this. I will directly place their reply. At page 285, this is their reply.
This is on bank letter.
No, Lordship, their advocate's letterhead. 285.
282.
282 is bank's
Bank's
letter.
letter.
This is from which they say that they have drawn knowledge that the bank has classified their account as an NPA.
Yes.
Then is 14/12/2023.
Yes.
Lordship, even in this letter, there is not a single averment to the account being entitled to any benefit under any circular of the RBI. May I place paragraphs 5, 6, and 7? that during the month of April 23, the company faced trouble to carry on business with profitability due to sudden changes in the market, and in particular due to want of adequate working capital, labor unrest, shortage of raw material, and other unforeseen and adverse situation. My client did not reach the expected profitability, and therefore repayment of the bank was irregular since August 2023. That my client made a proposal on 23rd November, this and this, for restructuring the account, which is still pending consideration. This, even in this, Lordship, I have shown that there also there was no averment as to be there, being there as to be an MSME. Even here, this proposal is just reiterated, and there is nothing showing that they had stated that they were an MSME entitled to any benefit. That my client says that if the above mentioned loan restructuring proposal is approved by the bank, company will survive as its own position. However, during pendency of the said proposal, which is under consideration of the bank, whatever, the bank has not furnished you details and all to indicate that here there was not a single averment that it is an MSME. Now, Lordship will kindly take.
How much time? It will take time. No?
Lordship, I will take some time. Lordship, may I come back tomorrow? Tomorrow, can it be taken up as a fixed matter, Lordship?
Fixed matter कल कोई adjourn हुआ नहीं हुआ ना? Adjourn motion, it will come up. I am thinking.
Because tomorrow, Lordship, second half, Lordship has company matters actually. That is why.
उस वक्त में 11 11:30 है. दूसरा कोई डेट है? Counsel for the plaintiff has concluded his argument. Counsel for the defendant has argued at length, but due to paucity of time, hearing could not be completed. Fix नहीं है. तो फर्स्ट डेट 12 12:30 है. अगस्त में नहीं. 2nd September कितना बजे? 2nd September 11:30. Yeah. Otherwise, let it be in the list. We'll see to that.
Lordship, let it be in the list in that.
Let the matter appear to me.
I'm obliged.
Let the matter appear to me.
But the interim order is due to expire 8th of August.
8th of August. Tomorrow it will come.
Tomorrow. Yes. Lordship, my application for acceptance of written statement is the GA3, only 30 days delay after 30 days. Lordship, that is also.
I will see.
I'm extremely obliged.
My lord, before my lord takes up the 3 p.m. matter, the next matter was ours. My lord, since yesterday it was fixed at 3:45 p.m. We couldn't, my lord, any day when this is a subway matter, my lord. My lord takes it up for lordship's convenience. I spoke to my learned friend. Can be fixed on 21st August, my lord.
Item number
27. Item 27.
कोई 3:45 में कोई खाली है? नहीं है. Problem is time is not.
21st, 22nd.
Before September, it is very difficult.
25th. Any day which is.
I have no idea. It has gone to September.
26th. 26th.
What time? 26 Tuesday. लिखो.
26 August হচ্ছে.
3:45.
Item number 27, na? Due to paucity of time, the matter could not be taken up for hearing today. Let the matter appear on 26th August at 3:45.
My lord.
Interim order. Will the interim order be extended till?
It's expiring on 8th.
Interim order is extended till 28th of August 2025 or until further order.
We also have an application on the written statement. If the written statement can be taken in, because there is no opposition to that, my lord. Since
I will take that. On that day, I will.
Fine.
I'm appearing for the appellant lordship. I'm led by Ms. Archana Shankar. We had concluded our submissions, Lordship, and the respondent was to start. Ms. Shankar may give a recap because, Lordship, we have completed our submissions long back. So, as my Lord pleases.
Yes.
So, Lordship, on 10th of November, Your Lordship, we had filed a detailed written submissions 10th November 2024. And on 20th of September 2024, Your Lordship, we had filed a compiled list of cases that we've relied upon in our written submissions, Your Lordship. Lordship, just to kind of recapitulate what this case is all about, Your Lordship. This application, and Your Lordship, for convenience, I'll just say the last 3 digits of the application, 708, Your Lordship. This is a division. Your Lordship has a written submission, Your Lordship, probably.
Written submission. हियरिंग हुआ था
हमें भी नहीं मिला ये हाँ वो भी है और ये भी है Lordship, I may hand over another copy till my Lord.
Yes.
So, Lordship, if you see my page number 2, Your Lordship, I have given a list of dates. My application IN 708 is a divisional application under Section 16 of the Indian Patents Act of a parent application 3985 call NP 2012. So, Your Lordship, the list of dates, the first block is the details of the parent application, and right below that is the details of the divisional application. Today, I am before the Lordship in relation to my divisional application 708, which was rejected by the Controller Wide Order 5th of March 2024. Now, Lordship, what was the case about, Your Lordship? My parent application was filed with, Your Lordship, if we come to the next page, Your Lordship, point number 1, Your Lordship. My divisional application is a combination of 2 drugs. One drug is called ibrutinib. That's the easy name, the INN name, the international non-proprietary name given by the WHO. It's a small molecule. It's a chemical molecule, which is in combination with an antibody. So, Your Lordship, antibody, we all know it's a very complex, like vaccines and all that. And there are 2 specific kind of anti-CD20 antibodies, which is ofatumumab and rituximab. So this is a composition or combination of a small molecule, specific small molecule, and an antibody. The technical problem of my invention was, Your Lordship, that whenever any person was injected with an anti-CD antibody, Your Lordship, they developed some what we call, Your Lordship, IRR. Yes. And that's at paragraph 12, Your Lordship, of my submissions. Just to very quickly, and I'll come to that in a moment. IRR is, Your Lordship, infusion-related reactions.
Correct.
Which means that you have to immediately stop a treatment to a patient who is suffering from cancer. Your Lordship, these are all cancer conditions. So my invention was to overcome the problem of a side effect which resulted in stopping a treatment with an antibody by combining an antibody with a small molecule ibrutinib.
Correct.
In my specification, Your Lordship, and I will just quickly take you through those, my submissions, it's all there, Your Lordship, provided clinical data to demonstrate that the effect of these side reactions was significantly reduced and a cancer patient could continue the treatment. Your Lordship, in cancer, we are essentially looking at how to improve a lifestyle of a person and increasing the life of a person, life expectancy. This is briefly, Your Lordship, what my divisional application is about. I filed a parent application, Your Lordship, 3985 call NP 2012. It had 133 claims, Your Lordship, which is at volume 3, point number 2, Your Lordship.
Yes.
All the claims, Your Lordship, were directed to a method for treatment of my parent application. Therefore, what I did was, Your Lordship, I filed a request for amendment in my parent case, and I limited my claims of the parent to one compound, only compound, no combination, nothing, Your Lordship. There was a hearing notice, Your Lordship, issued in the parent application on 5th December 2003. Therefore, the claims that were currently on record in the parent were a single compound. In the meantime, Your Lordship, under the Patents Act, I filed a divisional application for the combination.
Yes.
And I did not pursue my parent. I am under no obligation that if I file a divisional, I have to pursue a parent. I can give it up, Your Lordship, because a divisional application has its own independent identity. So I pursued my divisional application for the combination, and my parent, which was for the compound, was abandoned by me because I was not interested in pursuing that, Your Lordship. Your Lordship, then there was a first examination of item number 5, Your Lordship. A first examination report was issued in my divisional application, and the controller clearly said that your divisional application is clearly supported by the parent case, which means that I have clearly support of my claims for the divisional in my parent. There is no two opinion about that, Your Lordship. But when the Lordship, the Honorable Controller comes to a decision in this case, Your Lordship, the Controller begins to examine my parent application.
Leaving aside the divisional.
Instead of the divisional. And Your Lordship, for a moment, Your Lordship, if you have, Your Lordship, the first volume, Your Lordship.
Yes.
And very few paragraphs, Your Lordship. I'll just take, Lordship. Page 29, Your Lordship. That's the order of the controller.
Yes.
It starts at page 28, Your Lordship. It says it's a very dim copy, Your Lordship. At the time of paragraph 2, at the time of filing of the parent application, there were 129 method for treatment claims. On 24 December 2012, the applicant amended 129 method of treating to 33 product claims by filing of Form 13. So, Lordship, this is all under the parent application, amendments and everything. Then point number 4, at the time of filing of the divisional application, the applicant completely changed the entire scope of the originally filed claims and the amended claims into a combination claims. Which, Your Lordship, this is the first error because the decision of the division bench of the Delhi High Court. And Lordship, if you have the case law compilation of 20th September 2024, Your Lordship.
Compilation कहाँ है? कुछ भी नहीं है, कहाँ गया? Yes.
So, Lordship, this is the Syngenta versus Controller of Patents order at page number 5, which is a division bench order of the Delhi High Court on divisional applications, Your Lordship.
Yes.
It starts at page number 5.
Yes.
And Your Lordship, para 21 at page number 16.
Page number 16.
Yes.
We are inclined to agree with the submission of Mr. Anand, who draws our attention to the fact that Section 16 does not employ the expression disclosed and claimed or claimed in the latter part of the provision. This provision only speaks of inventions disclosed in the provisional or complete. We thus find no justification to read Section 16 of the Act as prescribing that plural inventions must be found or stand reflected in the claims. In fact, Such an interpretation would amount to rewriting the provision itself. The view to the contrary, as propounded in Boehringer Ingelheim, is thus disapproved. And then, Your Lordship, para 31. At page number, Your Lordship, 25.
Yes.
We find ourselves unable to subscribe to the view expressed in Boehringer Ingelheim, and when it seeks to base its conclusion on the precept as formulated by Lord Russell for the following reasons, additional reasons. It would be opposite to recall that section 16 speaks of both provisional or complete. However, in case of a provisional filing, claims need not be specified. If the view as expressed in Boehringer were to be accepted, no divisional application would be maintainable in case where a provisional application has been presented. This, since the decision bids us to discover the invention solely in the claim. We are thus find ourselves unable to concur with the view as expressed in Boehringer Ingelheim, and the said judgment shall consequently stand overruled. We hold that the divisional application moved in terms of section 16 would be maintainable provided plurality of inventions is disclosed in the provisional or complete specification that may have been filed. Therefore, Your Lordship, based on this order of the division bench, Your Lordship, the controller to say that I changed my scope of the claims from a compound to a composition combination is incorrect for the following reasons.
Yes.
A, Your Lordship, if Your Lordship has my paragraph number 8 of the submissions, Your Lordship.
Yes.
At no point did I change the scope of my claims. Because my claim 1, Your Lordship, sees a table there, Your Lordship. My claims from day 1 in the division were for a combination, and at the time of refusal was for a combination. So I never changed the scope of my claims. So that's the first error, because the controller went to examine my amendment in the parent case. Now, Lordship, para 6, the second error. The applicant filed form 30, that's the order, Your Lordship, at page 30.
Yes.
The applicant filed form 13 for voluntary amendment to the claims on 24 December 2012. But the amendment was not moved in the divisional application. It was moved in the parent application, and subsequently filed a divisional application on 20th November 2018, where the entire scope of the claims were beyond the scope of the originally filed claims and subsequently amended claims. But I'm allowed to do that, Your Lordship, in view of the Syngenta order. Anything which is disclosed in my patent specification, as long as it relates to a different invention, I'm allowed by virtue of the order of the Honorable Division Bench in the Syngenta case to claim it in my divisional application.
Correct.
And then, Your Lordship, he examines the amendment provision, section 57(2). The applicant stated that the amendment is restrictive and is supported by the specification and is within the scope of the originally filed claims, and the applicant is not obliged to submit any other reasoning behind the request for amendment. So, Your Lordship, the premise on which my divisional application was rejected, number 1, was incorrect, is contrary to the position taken by the division bench. Secondly, Your Lordship, my amendment was never a subject matter of the divisional application, but that amendment was filed in the parent application. Third, Your Lordship, in the first examination report, which is point number 5, Your Lordship, I have extracted the first examination report of the divisional application.
Yes.
Lordship, it's a little small, sir, Your Lordship, but it says that the divisional application deserves merit of the divisional application. So in the first line, Your Lordship, hence the instant application deserves the merit of a divisional application. Your Lordship, it's a box on page number 4, Your Lordship, right above the 6th paragraph, where I've taken a snapshot, Your Lordship.
Yes.
So on one hand, he recognizes that my invention is entitled to the status of a divisional application, goes on to examine my merits of my case on an amendment which was never filed in the divisional application. My parent is abandoned, which was directed to a compound, Your Lordship. So there's no overlap of the claims. which is now not even pursued. Now, Lordship, quickly, Your Lordship, to the Your Lordship, I've already read out the decision of the Division Bench of the Delhi High Court. Your Lordship, on page number 9 of the written submissions.
Yes.
The surprising and technical advantage of my invention, Your Lordship, para 12, Your Lordship.
Yes.
The problem with administering anti-CD20 antibody was that it resulted in infusion-related reactions that resulted in discontinuation of the treatment. When a BTK inhibitor, ibrutinib, is given with anti-CD20 antibody, it reduces the immune-mediated reactions caused by anti-CD20 antibody, and therefore there is a clearly synergistic effect. The patent specification extensively provides different forms of the compositions, and example 5 clearly provides support for the compositions. Your Lordship, point number 5, the data filed in response to the first examination report demonstrates that the combination of ibrutinib with anti-CD20 antibody provided excellent efficacy. So, Your Lordship, in the specification, I have examples 5, 14. Lordship, if Your Lordship wants me to show you the example, Your Lordship, it's at volume 2, Your Lordship, at page 298.
Yes.
Your Lordship, 298, right at the bottom above para 618.
Yes.
It shows phase 2 study of BTK inhibitor and ofatumab. So these phase 2 is nothing but your clinical trial studies. Then, Your Lordship, the next page. Then we talk about, Lordship, para 2, 626, right at the bottom, the primary outcome of the clinical trial phase 2, the secondary outcome. The entire clinical trial protocol has been described. And then, Your Lordship, at page number 306, volume 3, Your Lordship.
Yes.
I also talk about clinical trial study of BTK inhibitor in combination with ofatumab. So there was significant data in the patent specification to allow this composition or combination of a small molecule ibrutinib with an antibody. Lordship, last but not the least, page number 11, Your Lordship, of my submissions, Your Lordship. Para 14. I've relied on some cases, Your Lordship. Syngenta, Your Lordship, of the division bench, I just read out, Your Lordship. The second decision, Your Lordship, is of the Madras High Court Gen Square. And Lordship, it's a part of the compilation, page number 27, Your Lordship.
I will see to that.
And then the Victaulic, where all divisional applications were allowed in view of the division bench.
Yes.
So, Your Lordship, this case of disallowing my divisional was contrary to the position taken by the division bench of the Delhi High Court. Second, it related to a distinct invention, a different invention, different from that of the parent application. There was no scope for reviewing my amendment, which was filed in the parent application, which was not before the controller for examination. So, Your Lordship, therefore, my humble submission is that the patent should be granted, Your Lordship, and allowed to proceed to grant, Your Lordship, because we've already lost, Your Lordship, almost 14 years, Your Lordship.
Okay, thank you.
Thank you, Your Lordship. Much
Yes.
obliged.
This is my written support.
Yes, madam.
My lord, the divisional application was filed by the petitioner on 20th November 2018, my lord, with the title "The Use of Inhabitants of Triocene Quiescence for the patent applications, my lord, filed on 14 December 2012, my lord. At the time of filing of the patent application, my lord, there were 129 method of treating claim, my lord. On 24th November 2012, the petitioner amended the 129 method. My lord, kindly come to page 270.
270 of application.
Volume 2.
Yes.
My lord, kindly have a look, my lord. There are total 129 claim, my lord. My lord, last page is 282. 14 December 2012, my lord.
Yes. 282.
Total there is 129 methods.
Have you got?
My lord, kindly at last, my lord, page 282, 129. Two 129.
Your Lordship is actually 307, Volume 2, Your Lordship. Volume 3.
Maybe.
Paper book.
Paper book. I have paper book, my lord.
Where from you got that paper?
That is
Not
the
for me, my lord.
the paper book, Lordship.
My lord, I have paper book with me, my lord.
Take my copy.
हाँ hearing के आई हम बोलते मेरा मार्क नहीं है कुछ भी.
My lord, I have prepared as for the
There
paper book.
was a paper book, a submission, compilation. There were quite.
डिपार्टमेंट में क्यों जाएगा?
ठीक है अभी के लिए. The similar page 282 of the paper book is 307 of volume 3 of the petition.
No. 307. Nothing.
My lord, then kindly fix the date that any day, my lord. My lord, I have prepared as for the
Lordship,
paper
my
book.
paper book, I have given a copy of my paper book, Lordship.
Where is the paper?
I just give.
So how many volumes you are having?
Check 5 volumes.
You are having, then you have to supply the 5.
There is total, my lord, 6 volumes.
6 volumes.
Yes.
Page 270. Start from page 270, my lord.
282. 129 claims.
29. Claim, my lord. My lord, on 24th December, the petitioner amended the 129 method for treating claim into 33 product compound claim, my lord. My lord, I have annexed for convenient, my lord, I have annexed the same with my notes, my lord. Page 22.
Yes. So 33. It is 33.
From page 22 to
Correct.
24, total is 33, madam.
Yes.
My submission is right, my lord, but there was not even a single composition claim either in the amendment set of claim or in the original file claim, my lord. At the time of filing divisional application, my lord, the petitioner completely changed the entire scope of original file claim and amended claim into combinations claim, my lord. The petitioner filed Form 13 for voluntary amendment to the application on 20 December.
Where is the decision of the additional subdivisional claim?
Controller. My lord, kindly come to page 856, my lord, of volume 6. Paper book, volume 6, page 856. Right, Sheelam?
Yes.
My lord, my submission is this, my lord, that the petitioner was given the opportunity for hearing also, my lord, under section 14. And my lord, there is no doubt, my lord, that the petitioner can have a right to amend the application, my lord, completely specification or any document relating thereto till expiry of the patent. But my lord, it does not mean that the application can be amended according to their wish, my lord.
No, can you take the divisional application along with the parent application?
My lord, kindly come to section 57(2).
Correct. What says?
Patent Act. My lord, page 858, my lord, of the volume, my lord, this section was set out, my lord. 858, my lord.
Yes. Every application for leave to amend an application for patent or a complete specification or any document
Shall give
relating
full
that.
particulars of the reason for which the application is made, my lord.
Reason for the application is made. Correct.
My lord, kindly come to page 859 of the order, my lord.
Yes.
Then last paragraph, my lord. It has been written, my lord, for any amendment to claim, following 3 conditions shall be satisfied to the controller, my lord. One is nature of the amendment. Second is full particulars of reason for the amendment. Third is the proposed claim shall fall within the scope of lastly submitted claim, my lord.
So if a person abandoning the parent claim and coming with the additional and divisional application, what would be the effect?
My lord, sorry, pardon, my lord.
Initially the parent claim.
Yes, my lord.
Parent claim has been abandoned and divisional application has come. What would be effect? You will take the divisional application along with the parent claim, or you will decide the divisional application as separate. That is the argument they have made.
Separate.
And your authority has taken into consideration taking as an amendment to the parent claim and pass the order.
My lord, then kindly direct the authority to pass a reason order, my lord. That will be better.
That is the main submission they have made.
My lord, I heard, my lord.
And the Delhi High Court judgment.
Yes, my lord, I heard. So, my lord, it will be, if your lordship.
Yes, madam.
Lordship, this order may be set aside and the patent be granted. We've already lost 13 years, Your Lordship. Patents have been granted in all jurisdictions except India.
Fix a time within this time they will.
Lordship, we can't be going back and forth before the controller again and again, Your Lordship. Granted in many jurisdictions.
First time, my lord, not.
We've got commercial products over it, Your Lordship. Clinical trial studies were so effective.
2012.
But my lord, the rejection was the first time. No, my lord.
Does not matter what.
My lord, can we fix the time limit within that they will do?
Okay. Hearing concluded, CAB.
My lord, my written notes of argument kept on
Both are part. This counsel for the ऊपर आ जाएगा. Counsel for the respondent file the written notes. Let the same be complete the record. Hearing concluded, CAB.
grateful, my lord.
Grateful, my lordship.
Your Lordship, in this matter, I'm for the judgment data. Due to my senior's personal difficulty, Your Lordship, I am praying for adjournment.
फिर हो गया none क्या है? You are offering for?
Judgment data, Your Lordship.
Who is for the decree holder?
Decree holder is Your Lordship. Datta and Datta. Your Lordship. Your Lordship, we have already filed an application under Order 21, Rule 34. Read with Section 145 of the Civil Procedure Code, Your Lordship. This application challenges the mentability of the execution proceeding initiated by the decree holder, Your Lordship.
For what?
Yes, Your
On
Lordship.
what ground?
Yes, Your Lordship. Your Lordship,
Okay, then nobody is there. Not today.
not today.
Your lordship, I'm here for the
Asha,
petitioner.
Asha.
My senior counsel is not well, so he will not be able to come. My senior counsel is not well, so he will not be able to come. So I seek it not today.
Not today. Come tomorrow.
And for the decree holder, my lord. Last direction was the matter is appear on the 12th August, but it is appear.
Yes. Yes.
So this is my injunction application.
Injunction application.
I'm sorry, Milord. My execution application. I'm sorry, Milord. But here, Milord, the last order of your lordship, Milord, was directed the decree holder to file a supplementary affidavit, and the matter has been made returnable on the 12th of August. Milord, this order was given Milord on the last occasion on 31st, Milord. The rising of the court, Milord. And thereafter, the very next day, the matter again appeared. I thought your lordship perhaps have recalled this order, Milord. Milord, here, Milord, if your lordship recalls, Milord, there was a confusion with regard to issuance of warrant of arrest. I have, Milord, made a compilation to indicate, Milord, that I am led by Mr. Dr. Milord. Series of orders, Milord, and the correspondence that we have done. But here on the 28th, Milord, the first warrant of arrest was issued.
28th February.
28th of February, Milord. That's at page 1.
Correct.
Page 3 of the order. That if your lordship sees, Milord, page 3 of the order, Milord. Page 3 of the order, Milord. At the middle, Milord, little below the middle, in view of such. About, Milord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. There was 16, the 16th line, Milord. In view of such. In view of such, the registrar or other side of this honorable court is directed to issue a warrant of arrest.
Correct.
In them. Milord, thereafter, Milord. So thereafter, immediately thereafter, Milord, I have deposited the requisite, Milord, which is at page 5. Thereafter, Milord, at page 6, Milord, is the warrant of arrest. Thereafter, Milord, your lordship would find, Milord, at page 9, the matter was made returnable. Since, Milord, no report was filed by the police authorities, Milord, your lordship was pleased to show cause, Milord. And the matter was made returnable on the 23rd. Your lordship now takes, Milord, page 10.
After 4th, my lord, we got hold of a different address. And this is D21 Vijayanagar. This is on the 14th of April, we came to know of the different address, my lord. Now, if your lordship takes, my lord, the next page, my lord, on 23rd of April, my lord, your lordship was pleased to, my lord, issue another warrant of arrest in the new address, my lord, which is at page 10.
Page?
My lord, your lordship takes, my lord, page 11. Your lordship, my lord, takes page 11 is the order dated 23rd, my lord, at page 12. Your lordship was pleased to paragraph 5 counsel for
Officer
the
in charge Patna is as well as the senior superintendent director to
D21. That's the second address which we found, my lord,
Correct.
which I just showed your lordship.
Correct.
And your lordship was also pleased to record, my lord, no show cause was filed.
Correct.
On the previous page, your lordship was further pleased to direct the police authorities to file a show cause as why report was not filed.
Yes.
Immediately thereafter, my lord, again I deposited the challan, my lord, which is at page 13. This is the challan with regard to the second warrant of arrest.
Correct.
My lord, at page 14 is the second warrant of arrest. If your lordship takes, my lord, page 15, your lordship would find in the second paragraph, these are therefore to command you, the deputy sheriff, to arrest Navneet Vasta, a partner of Aparajita, now residing at D21 Vijayanagar. This is the address, my lord, which we found.
Correct.
My lord, now if your lordship takes, my lord, order dated, my lord, this is very crucial, my lord, order dated May 8th, my lord, which is at page 17. My lord, your lordship was pleased to note after this was, my lord, may I just read the order, my lord. Mr. Ayan Dotto, learned advocate, is appearing as the key holder. The Deputy Sheriff of Calcutta has submitted report dated 8th May, wherein it reveals that the Senior Superintendent of Police Patna has submitted his report, wherein it is stated that the address of the alleged contender number 2 mentioned in the cost title falls under jurisdiction of Gandhi Maidan Police Station, Patna. After inspecting by the Gandhi Maidan Police Station, it is found that Lakshmi Palace was found closed. Owner of flat number 206, Sri Pawan Kumar informed Aparajita Enterprise that Aparajita Enterprise was active in flat 103 in the past, but warranty Navneet sold the flat in 2021. Well, this particular address is with regard to the first warrant of arrest.
Correct.
If you the cost title address, then your lordship, my lord, was pleased to direct, my lord, the deputy sheriff to, my lord, circulate the report, as we did not have the report. We did not know what the report was.
Correct.
So, my lord, your lordship made the matter returnable on the 24th.
Correct.
The next page, my lord, is the report. If your lordship, my lord, takes the second paragraph of the report, this, my lord, I'll just read the, my lord, the particular portion, my lord, which reveals that the address of the warranty mentioned in the warrant of arrest doesn't fall under the jurisdiction of Patrakar Nagar Police Station, Patna. The address actually falls under the jurisdiction of Gandhi Maidan Police Station. After inspecting by the Gandhi Maidan Police Station, it could be learned that Lakshmi Palace was found closed. This Lakshmi Palace is again the address of the cost title, the first warrant of arrest, my lord. But we could not apprise your lordship the previous day because we did not have the report, my lord. So, my lord, this was only given pursuant to your lordship's direction on May 8th. After that, we got this report. My lord, then the matter came up before your lordship on the 24th of June, my lord. If your lordship now takes, my lord, paragraph 3, my lord. The registrar of this court was forwarded the report to the learned counsel for the decree holder. Counsel for the decree holder submits that on 2nd May, the decree holder has submitted the requisites of Office of the Sheriff of this court requesting for execution of warrant of arrest against the judgment debtor, namely Thakur Navneet Vats, as the address of D21 is the, my lord, the second address which we found out.
Yes.
This is the correct address, my lord.
Correct.
If your lordship takes, my lord, if your lordship turns over, my lord, counsel for the judgment debtor submitted that there is no report furnished by the Office of the Sheriff whether any warrant was issued against the judgment debtor in the said address or not. In view of the above, the learned master is directed to enter into the matter whether any warrant is issued against the judgment debtor at the address mentioned above. That's, my lord, the D51, right, 41. If not issued, take appropriate steps for issuance of warrant. This was your lordship's order, my lord, and the matter was made returnable on 24th of July.
Correct.
My lord, this was the, my lord, first warrant. This was the second warrant of arrest which was issued, my lord. Now, if your lordship, my lord, takes page 22, my lord, after getting after my lord, lordship order, my lord, I immediately wrote to the registrar, my lord, inquiring about the status. If your lordship takes the last paragraph, my lord, since it appears from the record that the warrant of arrest has already been issued against Navneet Vasta, I would request you to apprise me about the execution and current status of the said warrant of arrest. This is, my lord, the second warrant of arrest I am talking about. My lord, then, my lord, is the next page, page 23, my lord. Then, my lord, this report is given 14th July 2025, my lord. Now, my lord, if your lordship takes, my lord, I will read, my lord, paragraph 1 first, my lord. That is, my lord, paragraph 2, my lord. EC Com 312 of 2024 had been lodged with this office for the first time on 12th March 2025, and report had been submitted before the Honorable Court concerned on the fixed returnable date, that is 4th April 2025, in obedience of the order dated 28th February. This is with, this is the first, my lord, with regard to the first warrant of arrest, my lord. Now, my lord, point 2, my lord, paragraph 2. EC Com 312 has been lodged for the next occasion on 2nd May 2025 with the new address. This is, my lord, the present address, my lord. D21 Vijayanagar, Hanuman Nagar, Kankarabad Police Station, Patrakar Nagar. So then your lordship, my lord, comes to the next paragraph, unnumbered paragraph. Unnumbered, same, my lord, paragraph number 2, continuation. The same original warrant of arrest with the new address has been dispatched to the concerned police authorities with appropriate direction. Subsequently, report has been submitted before the Honorable Court number 38 on the fixed date of May 8. My lord, here, my lord, is the confusion, my lord. May 8th is pertaining to the first warrant of arrest, which I showed your lordship, my lord. Even
what has happened to the new
my lord, there is no report to that extent.
the new
Warrant of arrest has been, my lord, lodged, my lord, but there is no report from the learned registrar, my lord. That is the difficulty, my lord. There is, my lord, if your lordship, my lord, kindly, my lord, directs, my lord, another issuance of warrant of arrest, my lord, at the same address, I think that will resolve all the problems and confusions, my lord. It was just, my lord, there were 2 subsequent orders of arrest, warrant of arrest.
By which order the new address the warrant was issued?
My lord, that's 23rd of April 2025.
No.
Yes, my lord, that is 23rd of April, my lord. I'll take a that's page number, my lord. My lord, page 11 at 12, paragraph 5. This is the correct address.
So you submitted the warrant?
Yes, my lord. That's, I've showed your lordship, my lord. That's also important. And I'll, your lordship turns over to page 14, my lord.
Order dated 23rd of April 2025. This court passed an order directing the Superintendent of Police, Gandhi Maidan Road, as well as the officer in charge, Patna, are directed to execute the warrant against Mr. Navneet Vasta, who is the partner of Aparajit Enterprises, now residing इसको ना inverted comma करके italic करो, now residing at D21, Vijayanagar, Hanuman Nagar, Kankarbagh, KANKAR BAGH, Patna, -800020, Police Station, Patrakar Nagar, and directed to produce the judgment debtor before this court after his arrest. Police. As per the report, number next. As per the report of the Deputy Sheriff of Calcutta, it is found that the decree holder has submitted the warrant, and the same was dispatched by the office of the Deputy Sheriff of Calcutta to the Superintendent of Police as well as the officer in charge for execution. But till date, no report has been submitted.
That's at page 15 of the compilation.
Till date, no report has been submitted whether the warrant is executed or not, or any report has been submitted by the Superintendent of Police or the officer in charge of the concerned police station. In view of the above, the Deputy Sheriff of Calcutta is directed to submit the report whether the warrant issued against the judgment debtor at the address mentioned above is served upon the Superintendent of Police as well as the officer in charge of the concerned police station, and whether thus any report has been submitted by the concerned police officer be placed before this court on the next date fixed. Let the matter appear on 12th of August 2020.
May I only, my lord, seek an indulgence, my lord. Would it be your lordship's pleasure to, my lord, state that, my lord, the report filed by the, my lord, Deputy Sheriff dated 14 July pertains to the, my lord, first warrant of arrest.
Correct. That's why I'm asking with regard to the above mentioned address. That's why I clarify with regard to the above mentioned address. Yes, he has confused.
He was also confused. He's also confused. Your lordship, after your lordship gave us that good scolding, my lord, we found out everything.
Yes, next.
Grateful, my lord.
Yes.
May it please, your lordship. It's my turn to give the reply.
We are yet to, my lord, give, my lord, distinguish, my lord, a few of the judgments, my lord. Will not take long, but, my lord.
Yes.
My lord, facts, my lord, lordship would remember, my lord, that I am appearing on behalf of the heirs of the original plaintiff number 1. They want me, my lord, to be added, my lord, as party. I said that I am not.
You're not. Yes.
I'm not interested in the partnership. I have made that clear. And my lord, the law also does not require, my lord, my impleadment. I had, in fact, on this point, I had relied on, my lord, 2 decisions. And my lord, then I was possibly distinguishing, my lord, the cases cited by them, my lord. My lord, now kindly, my lord, take the notes which was filed by them. Looks like this, my lord.
Yes.
My lord, if I remember it correctly, lordship, my lord, keeps, my lord, very, my lord, the notes very meticulously, but if I remember it correctly, I had distinguished up to, my lord, AIR 1934 Privy Council, my lord, if I remember it correctly. That's at page 36 to 44. Or my lord, did I?
No, just you take a note. That's I'm. You are in AIR. Page 22. AIR 1967.
Oh, I see. Very well, my lord.
AIR 197. No. So you have relying over giving the reply to that only.
Very well. My lord, kindly come to, then in that event, kindly come
And
to page 22.
Yes, 22. Then you have marked until paragraph 5. Paragraph 5 you have.
That's true. My submission before your lordship was, my lord, that all these cases, my lord, speaks about rendition of accounts. Where, my lord, question of accounts comes in, my lord, yes. Otherwise, my lord, I am not, my lord, the heirs of a deceased partner are not required to be, my lord, impleaded as a party. And here I have shown your lordship the claim in the plaint and their counterclaim, my lord. None of it, my lord, speaks about any accounts.
Yes.
and dissolution is in fact, my lord, in dispute. Now kindly come to the next decision, my lord, AIR 22 Calcutta, page 201, at page 33 of the compilation.
Yes.
Kindly come to the first paragraph. This application under Section 11 of the Arbitration and Conciliation Act has been filed by the applicant for appointment of arbitrator to resolve disputes between the parties. Then, my lord, kindly turn the page, kindly come to paragraph 3. Submission of learned counsel for the applicant is that after the death of Dr. Dhrubajyoti Banerjee, respondents being his legal heirs are bound by the arbitration agreement, and that earlier arbitration had already taken place, and in fact after dissolution of partnership subsequently respondent number 1 was shown as partner, and that same objection raised by the respondent in the proceeding under section 9 of the act were rejected. So he was already a partner. Then, my lord, kindly come to the next page, paragraph 8. Learned counsel for the applicant has placed reliance upon the judgment of the Honorable Supreme Court in the matter of so and so, reported in 2009 volume 10 Supreme Court cases, wherein it has been held that with the termination of the contract, arbitration clause neither perishes nor becomes inoperative. That was the issue in this case. Reliance is also placed upon by the learned counsel for the applicant on the judgment of Honorable Supreme Court reported in 2007 Supreme Court cases, wherein the wide powers of arbitral tribunal has been recognized, and the judgment of the Honorable Supreme Court in the matter of Agrigold reported in 2007-3 Supreme Court cases, wherein it is held that Section 8 of the Act is peremptory in nature, and in a case there exists an arbitration agreement, the court is under obligation to refer the parties to arbitration in terms of the arbitration agreement. Having regard to the above circumstances of the case, I am of the opinion that the arbitration agreement in the form of partnership dated 20th May 1992 exists, and after the death of Dr. Dhrubajyoti Banerjee, respondents being his legal representatives are bound by the agreement to the extent provided by law. Now, my lord, this was a reference under section 11, my lord. Still question of section 16, my lord, is open to the parties. The dispute exists between the parties, hence present application under section 11 is allowed, so and so is appointed as arbitrator. The arbitrator will be free to decide the scope of arbitration and the issues to be taken up in arbitration in accordance with law. So everything is kept open. Now the next decision, my lord, they have relied on is AIA 34 Privy Council, my lord, the next page. AIA 34 Privy Council, page 138.
Yes.
Let kindly come to page 37.
Yes.
Let kindly come to, my lord, Lord Thankerton's judgment, my lord, second paragraph. Babu alias Govindas Krishnadas, who is appellant in all the appeal, was plaintiff in principal suit, which was filed through his next friend, Laldas, his uncle, on account of his then minority on 30th August 1923, and is the subject of the leading appeal. Appellant's father Krishnadas died on 13th August 1908, and the main question is whether his father's interest in the business carried on under the name of so-and-so was that of a partner or of a member of an undivided family. If the latter be the correct view, the appeals admittedly fails. If the business was a partnership, a question arises whether the interest of the appellant's father is affected by dates, kindly take note, is affected by dates, secured and unsecured, contracted by the firm some years after the death of his father's death, and if so, to what extent. Then, my lord, kindly come to the last paragraph in that page. The following facts may be taken as beyond controversy in the appeal. The appellant's ancestor, Ramdas Ghansamdas, came to Madras and carried on business in cloth, money lending and earned, and acquired landed properties, houses and gold and silver. He died in 1879, leaving 5 sons, of whom 2, Murli and Govardhan, were then major. These 2 sons carried on the business as the managers of a joint Hindu family business until 1890, by which time their younger brothers, Balmukund and Bhagavan had become major, while Shubraya was still minor. In 1890, as the result of a demand by Balmukund and Bhagavan and their mother, Kamalabai Amma, as guardian of Subbaraya, and submission by the parties, a Panchayat award dated 27 September 1890 was made, under which admittedly a partition was effected of the shares of the 3 younger brothers, and the family business was allotted to the shares of the 2 elder brothers, Murali and Govardhan, the younger brothers ceasing to have any interest therein. The principal matter of controversy is whether this award left Murali and Govardhan an undivided co-personer or as partner in the business, and if they were partners, whether there was a subsequent reunion between them. But without prejudice to these questions, it is the fact that they carried on business until 1906, when their respective sons Krishna and Gokul were assumed into active management, and thereafter it was carried on by them and the survivors until about 1919 or later, when the business began to get into difficulties, and ultimately on 28 November 1924, Gokul and Dwarka were adjudicated insolvents. Throughout the whole period from 1879 to this date, the business was carried on under the style of Murlidas, Ramdas and Co. In the opinion of their lordships, the first question to be determined is whether the award of 1890 effected a partition between the shares of Murli and Govardhan, and that depends on the construction of the award, in regard to which the subsequent acting of the parties is not relevant. Their lordships agree with the view of this matter taken by the trial judge, etc. This was the issue, my lord. The issue was completely different. And then, my lord, kindly come to page 41. Kindly come to page 41. At the top, in the present suit, the appellant seeks to recover a 1/2 share of inter alia certain immovable properties, which were owned by the partnership prior to Krishna's death. Certain of the respondents are secured creditors of Gokul who hold one or more of these properties as part of their security. The other respondents are the official assignees of Gokul's estate and certain unsecured creditors of Gokul. The main question is whether the appellant is entitled to have his claim satisfied out of the assets of the dissolved partnership, including the immovable properties in suit, in preference to the claims of any creditor, secured or unsecured, in respect of debts incurred by the firm long subsequent to the dissolution of the partnership by the death of his father, Krishna, or whether his claim is merely that of a creditor or the insolvent estate of the firm. If the latter to be held to be correct view, the respondents further contended that the appellant's claim failed to be postponed to the claim of the other creditors by virtue of section 262. There being no contract of partnership, the provisions of the Contract Act apply to this case without qualification, and the partnership was therefore dissolved by the death of Krishna. Then, my lord, kindly come to the next page, the second paragraph. It is clear on these authorities that the right of the representatives of the deceased partner is one of property, and does not rest merely on contract, and that the surviving partners who have the right and duty to realize the partnership property hold a fiduciary relationship towards the deceased partner's representatives as regards his interest in the partnership property, though the latter have no such right in any individual asset of the partnership property as will entitle them to interfere with the surviving partner's right to deal with and dispose of any such asset for the purpose of realization. Well, this is, my lord, the position. Now, my lord, the next judgment relied on is AIN 1971, Punjab and Haryana, page 186. Starts at page 45.
Yes.
Kindly come to the first paragraph. This second appeal raises a question about the abatement of a suit for dissolution of partnership and rendition of accounts. This is exactly where, my lord, I have tried to, my lord, draw the distinguishing line. In this case, in our case, my lord, there is no question of accounts.
Rendition account.
To appreciate the point involved, it is necessary to state a few facts hereunder. Now, kindly come to the right-hand column, my lord, second paragraph. In the present suit, settlement of accounts in respect of both the partnerships was asked for, making defendant number 1 liable in regard to first and both the defendants in respect of the second. The suit was filed by the plaintiff in his own name against the two defendants in their individual capacity, and no reference was made to the name of the firm in the title of the plaint. There can be no dispute with the proposition that in a suit for rendition of account, every partner is practically speaking in the position of a plaintiff or a defendant, and each one of them is liable to render accounts and pay the amount found due from him. Both the defendants filed written statement, and it was pleaded by them that the second partnership was only a sham transaction entered into for the purpose of income tax. My lord, it's not necessary. Now kindly come to the next page. Kindly come to paragraph 5. Page 46, my lord, running page 46. Kindly come to paragraph 5 of this judgment. The first contention of Mr. So-and-so is to be noticed only, to be rejected. It is a settled proposition of law that a suit for accounts cannot be maintained against some of the partners only, and that every partner is a necessary party. Suit for accounts. The reason for this rule is not far to seek. The shares of all the partners in the matter of their profit and losses have to be determined, and it is neither possible nor correct to decide the extent of right and liabilities of a partner in his absence. The cardinal rule of law is that no decree can be passed against a person in his absence. The argument of the learned counsel founded on Order 30 Rule 4 Civil Procedure Code is misconceived. It is only when two or more partners sue in the name of a firm and any of such partners dies that it is not necessary to join the legal representatives of the deceased as a party to the suit, but this provision has no application when the suit is not in the name of the firm. The present is a suit for accounts of a dissolved partnership filed by one partner against the other. In such a situation, if one of the partners dies and the right to sue cannot survive against the other, and the legal representatives of the deceased have to be impleaded as a party. Now here, my lord, I say that I do not want to be, my lord, involved in the partnership. The plaintiffs say that the, my lord, it stood dissolved. The defendants say no. I say that I do not want to be there in the business. Then kindly come to paragraph 6. The main question really to be determined is whether, in the matter of taking accounts, the entire period of two partnership is to be treated as continuing one, or that before 15th October 1955 there was a distinct and separate partnership between the plaintiff appellant and the defendant respondent number 1, which had already been dissolved and from which the deceased partner could be disassociated. It is true that once it is held that the right and liabilities between the plaintiff and the defendants number 1 could not be adjudicated with regard to the first partnership without the accounts
For the subsequent.
for the subsequent period being also taken. Channa Singh deceased was a necessary party and the suit could not proceed without his legal representative. Again, my lord, the question of accounts.
Yes.
My lord, kindly come to the next one, my lord, AIN 1994 Gujarat 206, which is at page 48.
Yes.
Kindly come to the first paragraph. The order passed by the competent authority at Bhavnagar on 7 July 1984 under Section 8(4) of the Urban Land Ceiling Act 1976 as affirmed in appeal by the common order passed by the Urban Land Ceiling Tribunal on 26 May 1987 intra alia in appeal number such and such is under challenge in this petition under Article 227 of the Constitution. By his impugned order, the competent authority declared the holding of the petitioners to be in excess of the ceiling area by such and such. Now, this was the issue. I can read out, my lord. It was, well.
Yes, yes.
And my lord, the last one, my lord, I am not very certain because 2017 Ford SCC 97 is possibly not referred to in the notes. আরে এটা কি রেফার করছিস কি?
Which one? Which one?
You are not relying on this. Page 51, my lord, my learned friend says that they are not relying on this. My lord, in view of this, my lord, in my respectful submission, none of these decisions, my lord, apply in the present facts of the case.
Yes.
My lord, the two Supreme Court decisions I have relied on, my lord, would, my lord, in my respectful submission, cover the field. And my lord, I am not, my lord, a necessary or a proper party in the present proceedings. No, no. There, Gulu. Certainly.
Yes.
My lord, those are made.
Let me first sum up. May I first sum up the submissions made, which is common to all the parties, my lord. The common line, my lord, are two broad submissions. One, that they do not want to become partners in the partnership firm. That's one, for which various reasons have been given, clauses have been shown, judgments have been shown. That's the first premise and the main premise, that through this, we do not want and we cannot be forced to become partners of the partnership firm. That's one. The second is that this petition, in fact, perhaps that's the first, this petition is misconceived, not maintainable in law, because your lordship has passed a decision which covers the field, and hence, through an amendment, substitution cannot be done. Two broad points, my lord. And I'll tell your lordship, I concede on both these 2 points, because that's not my case. First, my lord, the point of maintainability, that's the challenge thrown up, my lord. And your lordship's decision has been referred to and relied upon. Lord, I concede to that decision because that decision is absolutely correct, but my case is not that. I'll indicate why. Lord, kindly take up, Lord, page 11, which is the prayers in the petition. Page 11, my lord.
Of your application?
Of my application, my lord, GA8.
Yes.
But kindly see the first prayer is amendment. The second prayer, B, the death of plaintiff number 1 be recorded.
Correct.
Third, the persons mentioned in paragraph 8 hereof be substituted in place and stead. So it's not an amendment petition. It is not a petition under Order 6, Rule 17, my lord. It's a petition under Order 23. Order 22, my lord.
22.
Order 22, because otherwise these two prayers would not be there. So, my lord, today I can always ask for a lesser relief. My lesser relief in this proceeding is, my lord, not the amendments. It's B and C. I'll restrict myself only to B and C, my lord. if the amendment is required, and I'll show your lordship why this is absolutely wrong. My lord, kindly see the pleading in paragraph 13 of this petition. My lord,
No,
that's
paragraph
page 10.
8. What is the paragraph? Where is the paragraph 8?
Paragraph 8 is at page 9. It starts from page 8, my lord. Last paragraph at page 8.
Okay,
In
death
view of the
plaintiff number 1, naturally. No
and the names are given 1 to 6.
1 to 6.
Just the heirs.
That is the problem. How they can be implemented?
They have to be substituted, my lord.
How can be substituted?
But kindly see, my lord, in view of the aforesaid facts, circumstances, petitioner caused necessary inquiries to learn that they have. So, my lord, substitution is in the proceeding. It's not, my lord, that we are requesting or we are praying for a relief that they be added as a party as a partner in the partnership firm. That's not our prayer. That cannot be our prayer. I'll indicate why.
Correct.
Our contention is there is no partnership firm. So today, till that is decided in the, my lord, in the suit, my lord, till that time, we would never, my lord, make a prayer that let them be added as a partner. They cannot be made a partner in the partnership. There is no partnership firm. After, my lord, the notice which we had issued under section 43, there cannot be, my lord, a prayer. My lord, that is not the prayer also. That they be made a partner in the partnership firm, because our contention is always, my lord, is consistent. And that's also a counterclaim, my lord, that there is no partnership firm after our notice of dissolution under section 43. But the right to sue survives. And there is no submission, my lord, that the right to sue does not survive. I'll indicate why.
What is the suit for?
The suit, our suit, my lord, their suit is to declare that this notice which we had issued under section 43 of the Partnership Act, because it was a partnership at will, their contention is, my lord, that this should be declared as null and void. And, my lord, the steps taken thereafter, 2 days thereafter, my lord, 3 things happened. We issue a notice dissolving the firm because it's a partnership at will. They, my lord, immediately the next day, my lord, they throw us out of that non-existent partnership firm. 3rd day, my lord, they reconstitute the partnership firm. So now the suit, the broad premise is, my lord, they say that this notice through which section, my lord, the dissolution has happened according to us, be declared as bad in law, and the subsequential relief, my lord, that after this, the fact that we have thrown out this individual as a partner from the partnership firm, that may have sanctity of the court and the reconstitution. Our counterclaim in the proceeding is, my lord, to validate the notice through which, my lord, the dissolution happened, the declaration that it's a partnership at will, and thereafter, my lord, the consequential reliefs which flow thereafter under the Act from section 43, 44 onwards, my lord, 45 onwards. We've asked for accounts, we have done, my lord, the usual. So now, my lord, the prayer, so my counterclaim is limited to this.
Counterclaim?
Show me the counterclaim.
What is the prayer in the counterclaim?
I'll just, my lord, take that out. I'll quickly show that.
It's 66 of their application.
Just take out that. The prayers, my lord, are at page.
Written statement starts at page 16. The prayers are at page 16.
Yeah, 66. Preliminary decree dissolution for dissolution with effect on 13. Of the Rajuddin and Company.
May I read out the prayers? My lord, I have it in front of me. It's from another application that I'm reading out. The first, my lord, is a preliminary decree for dissolution. With effect from July 13, 2019. This is the date when we had issued that letter under section 43. Be continued and unconstituted by deed of partnership dated October 1 in form 21. Final decree for dissolution of the partnership in form 22. Alternatively, Messrs. Serajuddin and Company bearing having registration number and constituted by the deed of partnership be dissolved by this court. So, my lord, that's an alternative prayer under section 44. If 43 is not, my lord, considered. Then perpetual injunction, that's a consequential relief.
If you are telling that you are admitting that there is no partnership,
my lord,
then
I'm very grateful, my lord. We are admitting, my lord, because this is what we are seeking as a declaration. Today, my lord, this July 13, 2019 is a letter issued by us. Because, my lord, we contend it's a partnership at will. With that letter being issued, my lord, our contention is there is no partnership after this. their contention in the plaint is, my lord, a declaration that this notice is bad in law. Our counterclaim is, my lord, a preliminary decree based on that notice, because, my lord, then there's a dissolution which has happened, and thereafter, my lord, alternatively under section 44, if 43 is not considered by the honorable court, injunctions, my lord, that's prayer D, E, declaration that the expulsion is bad in law, my lord, I had indicated next 2 days, my lord, things happened. 15 July, so my lord, that's 13 July. 15 July we were expelled, that's, my lord, prayer F, that it is bad in law. And, my lord, reconstitution, that's prayer H.
When the plaintiff number 1 died. The notice is before death or after death?
Before death. My lord, I'll indicate, kindly take up that paragraph 8, my lord, of the petition. Page 8. In terms of this, your lordship will find from my notes, I'll indicate because it's all there in one place. But will kindly take up the notes once.
Yeah, you can.
16 June
16 June 2023, my lord.
Correct.
During the pendency of the suit.
Correct.
That's, my lord, in paragraph 5 of our notes. My contention is, my lord, the right to sue has survived and it has not been argued, my lord, the right to sue has extinguished. And I'll indicate why. My lord, kindly take up the act once. I'll indicate only the places where, my lord, the representatives are referred to. And I'm asking for a lesser relief today. My lord, out of all these prayers, all that I'm limiting myself is, my lord, prayers B and C. Kindly take up section 46.
Yes.
Rights of partners to have business wound up after dissolution. On the dissolution of a firm, every partner or his representative is entitled, as against all the other partners or their representatives. My lord, kindly mark this. My case is not that, my lord, they should be made partners in the partnership firm. My case is that they should be substituted in the instant proceeding.
What capacity?
As legal representatives, my lord. Legal heirs. Today, my lord, it's not amendment. That's my case. My lord, kindly see the prayer. I'm giving up that prayer. My lord, there are other prayers. It's not only amendment. So had, my lord, my prayer been only limited to amendments, my lord, I could not have made this submission. And that's where, my lord, the distinction lies with your lordship's decision in Thakurani, my lord. I'll indicate that because in Thakurani, my lord, if your lordship is pleased to take up that decision once, it has been handed over to your lordship. Thakurani Shri Durga Mata Jiu versus Kangali Charan Raul. It's an unreported decision, my lord. You have an extra copy? Extra copy,
Yes.
My lord. Lordship will find here in this, my lord, in this matter, there's only prayers made for amendment and there was no prayer for substitution. That's the distinction. That's prayer B and C. I'm sure my learned senior friend has not been indicated that. Prayer B and C. Only limiting to B and C. My lord, kindly see what happened in my lord, in this decision of Thakurani Shri Durga. My lord, you will find where the facts are recorded in paragraph 2.
Yes.
And thereafter, my lord, kindly take up paragraph 4. Prayer in the plain be amended by deleting the word possession, incorporating the sentence eviction, ejectment against the defendant. Then the submissions are recorded, judgments, my lord, cited. And thereafter, my lord, the contentions in paragraph 8, 9, 10, and from 11 is your lordship's, my lord, decision, where, my lord, order 6, rule 17 is quoted, and then kindly take up, my lord, paragraph 13 and 14. 13 is, my lord, the plaintiffs intend to elaborate the description of the suit property in these paragraphs. In paragraph 8, prayer portion of the plaintiffs intend to pray for eviction, ejectment of the defendant through, though the original prayer of the plaintiff in the suit was only for possession. So, my lord, kindly see, this is the only prayer there. This court finds that the said amendments will not change the nature and character of the suit. And this was allowed. At the end, my lord, the amendments were allowed. Paragraph 14. As regard deletion, but this is very important, my lord, because this is the bone of contention. As regards the deletion of the name of plaintiff number 4 on account of death of plaintiff number 4 and substitution of the legal heir of the plaintiff number 4 and addition to the name of the plaintiff numbers 8 and 9 are not permissible within the purview of provisions of Order 6, Rule 17 of the CPC. In the code, specific provisions have been provided for substitution of legal heir of the plaintiff on the death of the plaintiff. In the code, in the said code, there's also specific provision have been provided for addition of parties. In view of the above, court is of the view that substitution of the legal heirs of plaintiff number 4 and addition of plaintiff numbers 8 and 9 are not permissible. I have no quarrel with this. This is, my lord, absolutely, my lord, the position of law. It would have been the end of the matter, my lord, had there not been prayer B and C. And my lord, I'll show, my lord, there are decisions which your lordship is already, my lord, well aware of. I'm carrying them in, my lord. I can always reduce and ask for a lesser relief. I am asking for a lesser relief, my lord. I am only asking for B and C. I am not asking for the amendments, my lord, and I'll show, my lord, this is where we went wrong. Amendments actually cannot be permitted by the Honorable Court, and I'll indicate why. My lord, kindly take up the application once. Your lordship will kindly see paragraph 8 is where, my lord, we have chalked out the, my lord, legal heirs. That's a table. My lord, kindly see very interesting paragraph 13. This is our fault. Kindly see, my lord, page 10. And this is why, my lord, that prayer is misconceived. The prayer cannot be granted by the Honorable Court. Kindly see paragraph 13 and 14. 13 is, my lord, at page 10. The proposed amendments as indicated in red ink on a copy of the written statement and counterclaim annexed hereto and collectively marked with the letter be allowed. There is no, my lord, annexure. There's nothing with the petition. My lord, kindly see then paragraph 14, the proposed amendments indicated and marked with the letter B are formal. There is no proposed amendments, my lord. Formal in nature and cannot change the nature and character of the present suit. It's not there, right? It's not there. Shall not change the nature and character of the present suit. Amendments are necessary for determining the real questions and controversies between the parties. And then, my lord, kindly read it with prayer A. The proposed amendments as indicated in the red ink.
Yes. It is there.
In my copy, my lord, it's immediately after this, is the judgment. So, my lord, there is no.
Page amendments, my lord, we pointed out, it's all in red. Page 16.
It is there. That's why.
16 onwards.
Not only 16, all pages.
My lord, in that case, my lord, perhaps my copy is not matching, but in any event, my lord, in any event, I stand by my submission that, my lord, I am giving up this prayer. Today, my lord, I would not have been in a position to argue this had, my lord, and I would be guided, my lord, by your lordship's decision. So, my lord, I could not argue had there been no prayer B and C. Today, my lord, if I give up my prayer A, my lord, and D, I'm not pressing my prayer A and D. I'm only, my lord, limiting my prayer to B and C, and I can do that. My lord, I'll indicate, my lord, if I learn it. Today, I'll just indicate those judgments where, my lord, this position is there that I can always ask for a lesser relief. I do not know, my lord, whether I should come back one day, any day, my lord.
It's been fixed already. 7.
7, my lord, I'll conclude that. But, my lord, before that, I'll also indicate this. I'll hand over copies of these judgments so that, my lord, only if this is required, my lord, because this is a settled proposition, I may not be, my lord, relying on them.
My learned friend is really, my lord, re-arguing in reply, which...
No, I'm only indicating because, my lord, the reason is, my lord, the premise has been set wrong. So I'm only, my lord, trying to correct that record because today my premise is only this. I am not for once contending that they should be added as, my lord, they should be made partners in the partnership firm. That's not my case. My case is, my lord, the right to sue survives, and that's because of section 46. I'll indicate that, my lord, where the representatives part is there. My lord, also section 50.
Okay, come on the next thing.
My lord.
7th. Counsel for the.
That's what I'm saying. I didn't expect you to make this mistake. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7. 7
Plaintiff number 3. Legal errors of the deceased plaintiff number 1 has concluded his argument. Full stop. Counsel for the defendant number 1 / applicant in J8 of 2020 has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 7 at 7th August at 3:40.
I'll conclude in 10 minutes, my lord. I'll only indicate this, summarize, because those 2 points I have to answer, my lord. I'll answer that and reiterate and I'll conclude. I'm very deeply obliged.
Thank you.